Good morning, good morning, good morning. It is Thursday. I can't believe we're nearing the end of November. It's November 16th. I mean, I realize that's the middle of the month, but it feels like the end of the month to me. We have a lot for you today, and hopefully the internet decides to cooperate with me. If you missed Tuesday's stream, that was special. Today we are talking all things Murdaugh. On Tuesday, I had really hoped to finish up the Corey Richins case today. However, Judge Newman put a hearing on calendar for tomorrow for Murdaugh, so I couldn't leave the law nerds hanging. I needed to make sure that you were up to date before tomorrow's hearing. I have an appointment tomorrow that I cannot miss, so I need to cover that probably on Monday. So if you are not on the Law Nerd app, I am telling you now, Law Nerd app, I will be trying to break down what happens in that hearing either on Quick Bits or on social, and I will keep you up to date on the app where that's going to be, because there is a Murdaugh hearing tomorrow that is going to determine if this trial is going to go to trial. So replay crew, love you. There will be timestamps down below. We're going to do a quick little giggle of a Quick Bits today, and then we've got to talk about the Courthouse Becky response. Yes, that has to happen. And this change of venue or delay of trial that is applying to the trial that's supposed to start at the end of this month in front of Judge Newman. We still have stuff pending, so I'll do a quick road so far, because there's he's been convicted of murder. What is still happening? So much. There is so much still happening. So I've got coffee today, and I am ready for it. So hopefully you are ready. I am ready. We're going to roll the intro. We're going to get right into it. Law nerds, let me know where you're coming in from, what you're drinking. I got coffee from my coffee machine this morning, and let's go. Let's go. Let's roll the things. Let's do it.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Y'all, we're going to do some quick bits. First, we're going to say thank you so much to those who have gifted memberships. B2, always so incredibly generous. For those of you who are new members or have just gotten memberships, you will find a members tab, and you can go back and watch all the old members only live streams, yesterday's members only live stream, and you'll be around for Friday, next Friday's members only live stream, our kind of day after Thanksgiving, Black Friday, E and Dr. B members only live stream. So that will be happening next week. B2, you are always so generous. Thank you so much. And I'm so glad. I love seeing where you guys are coming in from. I feel like I've been so discombobulated with travel that the only way I want to travel is just by looking at what you guys are doing. Trinidad sounds amazing. Soup sounds amazing. That's definitely what I'm doing today. I love that you guys love being members. It's fantastic. So Tori in the chat, I saw you asking how to be a member. Look at what the mods post. They will help. Let's see. Just a mom said, whenever I try to link from the Law Nerd app, it tells me I can't watch the video because I'm not a member. That's very odd. Can you send us a screenshot of what you're getting to help at Emily D. Baker, and we will see what we can do to fix it, because it seems like it's dumping you into the wrong place on the YouTube app. So, I see some of you guys drinking hot chocolate, a favorite over here. Absolutely a favorite. Absolutely a favorite. I am very excited. Dr. B loves being here. And he's like, are we going to do our Black Friday stream again? I'm like, oh, we've done that for like the last 2 years, haven't we? He's like, yeah. And I'm like, yeah, let's do it. Diana, the murdacity, all of it. And one of the reasons Dr. B and I love doing the streams, I don't like traveling. During Thanksgiving, it's miserable. My parents also don't like traveling during Thanksgiving. It's miserable. So all of my family is like East Coast, West Coast, and then we're just in the middle. So we tend to hunker down and have a very build your own holiday type of a day with the kids. And on Friday, I really love getting together with all of you, because a lot of you are in the same boat where it's like quiet. And so we get to do our stuff together, check in, say hi, do all the things. And I love that. He loves that. And it's become a tradition for our house. Soma in the chat said I had mango and mango pizza this weekend. Dude, there is nothing quite like pizza at the Jersey Shore. There just isn't. Fight me. There's not. There's not. Look, I think New York has the bagel market cornered, but Jersey has the pizza crust. I know New York pizza. Chicago, don't come for me. I don't get it. I'm sorry, Chicago. I don't understand. You guys do all kinds of shit with hot dogs. It's amazing, but I don't understand the pizza. The New Jersey pizza crust, I think 10/10 better than New York. The New Yorkers are going to have words, but the donuts in Jersey, so good. So good. Sorry, Chicago. I know. I see it. We have started off the morning with a food fight. We have apps. You know what? That plays into our first quick bits. It absolutely plays into our quick bits. And we're going to go to our first quick bits in a second. Chicago is real pizza. Okay, look, here is my bias. I am deeply biased in this conversation. I can't eat tomatoes. So most of the Chicago style pizzas that are offered to me are deeply tomato heavy, where when I go to New Jersey, I can get like a buffalo chicken pizza that has no tomato. I can go to a white pizza, no tomato. Chicago pizza does not do the same. Chat, I see you. I see you fighting over pizza. Go ahead. It's all a matter of opinion. The Philly cheesesteaks are the best. Absolutely agree. Absolutely agree. I know. My Italian family is like, girl, what? I'm like, tomatoes. I can't eat tomatoes. I can't eat tomatoes. I also realized that this absolutely changes my perspective on what I can eat for pizza. Okay, there's white pizza in Chicago, just tavern style. What is tavern style? My problem is similar but different. I can't eat bovine-based cheese. See, this is a thing. Though goat cheese is amazing. Does that count? I'm not sure. Bovine's cow, right? Hey, people, I'm Italian. Don't let me start on pizza. I have not had pizza in Italy. So I'm limiting my food hot takes today to the United States. So that's it. That's it. To be fair, most pizza's delicious. You know, not all pizzas. Here's the best pizza in the world. The best pizza in the world is when it is steaming hot. You are kind of cold. You've been out for the evening. You're tired. You're kind of inebriated, but not sloppy drunk. And it's 2:00 in the morning. There is nothing more delicious than that pizza. I don't even know where you get it from. It doesn't even matter. It's situationally amazing. That is the best pizza ever. That is it. That is it. Cindy in the chat said, according to my son, pizza in Italy is amazing, but also Croatia. See, the international crew is going to be like, stop it, Americans. What are you doing? What are you doing? What are you doing? All right. Let us talk about food real quick. Perfect pizza scenario. That's when it's the best. But it's also like, what gyro is the best? This is maybe a very California specific thing. It's the one after the Hollywood Bowl from the street meat carts. They're the best. You've gotten out of a long concert. You're exhausted. It's a whole walk. You've got a whole drive home and you're going to be in LA traffic at 1 a.m. And like, why is there traffic at 1 a.m.? Because Los Angeles. And so that food is the best. It's situational. It's situational. Just like this coffee this morning. Situational. Jersey Boardwalk, yummy. But come to Jessup, PA, and we'll do a pizza crawl. Sounds amazing. I've been obsessed with pizza lately. I had 2 different kinds yesterday. Look, I'm here for it. LA traffic never ends. It doesn't. Now it's gotten worse. Let's talk breakfast burritos. Okay, that's a whole nother conversation. Somebody's talking about pizza cut into squares. Americans are wild. I feel like you stop eating square-shaped pizza when you're in elementary school. Maybe it's just me. All right. With all of you, let us talk about food. We're going to do a quick bit. And then a ton of you tagged me in something. I'm going to be real honest with you. I don't use Twitter a lot anymore. It feels like a fucking Thunderdome all the time. But I do look at the stuff you guys tag me in. So when you tag me in stories, I see them. I will sometimes heart them. But we have our own app. I can let you know where I'm going to be. Twitter doesn't share anything, it feels like. personal feelings. It does not feel like Twitter shares like, hey, I've got a video going live. It feels like the only thing that you really get on Twitter right now is Thunderdome shit. And that engagement, I don't feel to be positive engagement. A lot of it is Twitter brawling, and that's not the kind of, I love engaging with y'all. I love the positive engagement, the chatting, the having a fun, cheeky conversation over where you get the best pizza. I'm here for all of it. I'm not here for people just watching shit burn all the time. Or at least I don't want to be a part of it. I might watch from the sidelines sometimes. Let's be honest. But I don't really want to engage with it. I don't like fighting in that way. I don't like fighting on the internet. I don't need to prove to anybody that I'm right. I don't need to win anything. And I don't need to dunk on people for misspelling shit. And I like having conversations back and forth. And that's not really what the app is set up for. And that's not what bolsters the app anymore. So I will peruse the things you tag me in, because there are still things that are magic that happen there. And that is our first quick bit. This comes directly from the Law Nerds tagging me. Let's get into quick bits. Quick bits. Meant to go straight into quick bits, but then I saw some of you saying this in the comments, and you're absolutely right. The other thing I have a problem with Twitter now is that I can't always tell where the particular thread ends and where like a new thread begins. And there's all these weird ads with like, there's just weird shit in the ads. And I don't understand. And it's like, I feel too boomery to do it. It's hard. And so I'm like, wait, what is this random ad for something? I'm trying to read the thread, but it's ads everywhere. And then like the thread will end and then there's something else, but I don't realize the thread has ended. And I'm like, stop it. Bridget in the chat said Twitter is where nuanced conversations go to die, and nuanced conversations is what I enjoy the most. So it's just it's not in alignment with how I want to spend my time. I'm busy on my Suika score and trying to outgame Pokemon Sleep. Like, I have things to do. I'm so far behind on Housewives. We have things to do. So it's just not fun. But occasionally things are fun. This I find to be fun because it comes to us from Aldi Stores UK. Let me give you a little background. For those of you that are newish to the channel, a number of years back, our first food court story was a UK story about caterpillar cakes. Cuthbert and Colin, the caterpillars. I am obsessed with the caterpillar cakes. I have a Cuthbert back here. I am obsessed with the Cuthbert Colin feud. Aldi Stores UK Twitter was absolutely one of the greatest things I've seen on social media. I don't know who their social media marketing team is. All of the raises, equity in the businesses, they're incredible. So when this trademark suit over the caterpillar cakes came out, Aldi won social media. I think M&S might have had the stronger legal cake. Legal cake. They had the stronger legal cake. I think they might have had the stronger legal case. Aldi won the court of public opinion in a day, hands down, best ever. And they have continued to lean in to the Colin and the Cuthbert caterpillar cakes of it all. There are multiple videos on my channel. If you want to go back and watch me literally laugh at Twitter and at Aldi's social media team talking about the Colin Cuthbert silliness, you can go find those videos on the channel. It is so funny. MTH. This is a deep take. This is a deep cut, and I love it. Some of the chat will get the cake is a lie. Some of the chat will not get the cake is a lie. And thank you. So, with the caterpillar cakes, we are now in the stage where Cuthbert has come for the Great British Bake Off. And that is our first story in Quick Bits today. This is Aldi Stores UK Thank you to the law nerds that tagged me in this. You made my day, and I appreciate you. A letter to Channel 4 and Great British Bake Off. To at Channel 4. The way to start a proper legal letter is to use their at. Not legal advice. To Channel 4. We are the Intellectual Caterpillar Council to Aldi UK. We write to you regarding Channel 4's violation of Cuthbert's rights. Aldi has always been a big fan of the Great British Bake Off, and we've long craved a Hollywood handshake. But tonight's episode really took the biscuit. A caterpillar cake? Do you think that has legs? As I'm sure you know, Aldi is a globally recognized leading retailer of caterpillar cakes. Don't tell M&S. And we believe this infringes upon our copyright. At the moment, this is just us putting out our feelers. We're larvae, not fighters. We don't want a frosty relationship, and we're certainly not trying to sponge off you. However, Aldi is prepared to protect its caterpillar and pursue this matter to the fullest extent of the law. We certainly think a legal challenge would be a piece of, well, we think it would be easy. Therefore, we demand that you cease and desist from all further use of and agree to permanently refrain from any unlawful reference to or use of Cuthbert, including without limitation, use of the image unless the team crown Aldi Star Bakers for the rest of the series. That's amazing. Whilst Paul is dressed as a caterpillar. So they now have terms and conditions. We would like you to crown the Aldi Star Bakers, the team crown to be the Aldi Star Bakers for the rest of the series whilst Paul is dressed as a caterpillar. Hopefully this isn't a case of us trying to have our cake and eat it, and we can avoid a Great British face-off. Kind regards, Cuthbert's legal team. They do not want a Great British face-off. They would like to have their cake and eat it too. Again, this is the most British shit ever, and I fucking love it. Like the tweet. Oh, I forgot to like the tweet. We like it. It is so funny to me. Aldi's social media team is so damn funny. I wish I could see the quote tweets. I don't even know how to see them anymore. I love this humor. I love this use of social media. I think it's really funny. Fair play to the Aldi social media team. They are the best. Don't worry, we know. Thanks, Cameron. Cameron, we love you. Cuthbert is going to get pretty mad if it continues. You won't like him when he's angry. This made me laugh for sure and cheered up my day. I think I'm going to have to try one of your caterpillar cakes now and serve it for my birthday on Tuesday. Best birthday cake known to the human race, Cameron. Cameron, can you please give us caterpillar cakes in the US? Please? We don't have Colin. We'll be loyal to Cuthbert. It seems like the only option is to bring Cuthbert to the US. And fuck Colin. Like whatever. So this is just the funniest thing ever. Absolutely brilliant, Aldi UK, as usual then. Absolutely brilliant, usual standard. This is brilliant. Good work, Aldi X. How about a day off for good work? Brilliant. Cuthbert's legal teams are smart cookies. That just takes the biscuit. It's a lot to digest. Brilliant. Loving it. The council has spoken. Aldi Twitter just gets better. We're just too good. Brilliant from Aldi again. Got to keep up our standards. Supermarket X channel beef. Is it still beef if it's over cake? Brilliant marketing team. We're not biased, but yes. Love it. Love and passion was put into this letter. Absolutely brilliant. Need a Cuthbert cake to calm us down. I was hoping for this. We weren't. This is fantastic. Don't tell Cuthbert that. Brilliant. We tip our metaphorical hat. Like the amount of love that went into this social media team's post. Love this. Imitation is the greatest form of flattery. I can't get that image of Paul out of my head. Personally, I always eat the cake rather than have it. Could also be amicably settled with that Hollywood handshake. Anyone in the mood for cake? Pending a response. Can we count on your support? Piece of cake. Better than all the rest. Brilliant, Aldi. Just brilliant. You're simply the best. Better than all the rest. Fuck, their social media team is great. I bloody love it. I'm going to tell you all a quick story and then we're going to get to our second part. Because if you don't follow Aldi's UK Twitter, it's really fun. It really is. This is very fun. Wendy's also has a great Twitter. They do. There are some of these social media companies that have a really, really cheeky and fun Twitter. Here's a quick story. I was with a group of friends and husbands and everybody hanging out. And one of my friends' husbands was looking at something on my Twitter. Oh, here, Lawnards. We've gotten to this part. We've gotten to the part where the Lawnards have tagged me. Lawnards. You're the fucking best. There we go. Thank you, Lawnards, for all of the tags. I appreciate you. You are great. So we're larvae, not fighters. We were hanging around talking, and he's looking at my Twitter and looking at who I follow on Twitter. And it's like, why do you follow Aldi UK? And I was like, oh, let me tell you why I follow Aldi UK. And then we got into the entire Colin and Cuthbert of it all. Because last year they dropped a holiday video about Colin and Cuthbert. I imagine it will happen again this year. It made my day. It just makes me laugh. So this whole Twitter feed right now is just good job. Our legal team are on speed dial these days. Aldi UK, cough, cough. Look, Caroline the Caterpillar. They are making caterpillar cakes on Great British Bake Off. Look, here's what I appreciate Twitter for. The memes. I love seeing people being cheeky. People fighting, not so much. People being funny. Yeah, I'm here for it. There's some real clever shit that happens on the internet, and I'm about it. So this is their legal letter. Our lawyers, when we told them we were working through Bake Off, I just want an easy life. Judges and caterpillar cakes, just like the good old days. Calling back to the last legal battle over it. Cheers, mate. Carrots crying. I don't. TikToker made a claim she got a forehead tattoo and revealed it was fake. Okay. So their Twitter is hilarious. It is worth it to watch their social media play out because I think it's just really funny. I like the I like the cheekiness on social media. It's funny. It's funny. So with all of it, Kevin the Carrot. Yes, lots of Kevin the Carrot this year. All right. So with all of that, I appreciate you. I appreciate the funniness on the tweet on the street. I appreciate the Lawnards that tagged me. But this is why we follow Aldi UK, because they're funny. They're funny. Oh, wait a second. This is, for those of you that are like, what the fuck is a caterpillar cake? Go watch that episode. We'll link it down below this episode. One of these is not like the others. He's significantly nicer. These are all of the British caterpillar cakes. So, Cuthbert and Colin. Oh, and Colin Mummy. Oh, Amazing. Cuthbert and Colin were what the original fight was over. Cuthbert has changed a bit, and the box has changed a bit so that it's not just the same. But you've got Cuthbert and Colin and Connie and Colin, the mummified Colin, and Morris and Slinky and all the other ones. Because you've got to have a caterpillar cake. Apparently. I need to go back to the UK just to do a taste test of all of the freaking caterpillar cakes. Or at least Colin and Cuthbert. This. Miles the millipede, yes. I know. I need these in the US too. Aldi is the place to do it. M&S and Tesco are not bringing cakes to the US. But Aldi could. Aldi could. Anyway, it's a delight. For the UK crew, your favorite birthday cake as a kid is my favorite legal case of all time. So cheers. Thank you. The cakes are so cute. What are the flavors? I believe they're like a Swiss roll. They're like a chocolate cake with frosting rolled. The Brits can explain. Brits, please. The Brits can explain. All right. We need to go to our second quick bit. This was a longer quick bit than I anticipated, but I also want to let you know that it is time. It is time for today's sponsor. We have a sponsor today. So let us do that real quick. All right, y'all. Gerard Cosmetics is having their Black Friday comes early sale. My entire collab is up with Gerard Cosmetics. You can still get all of my lip glosses from Facts to, we didn't name any of them fuckery, Objection, Hearsay, and Facts are up for grabs, but also some of my other favorites. The eye primer, you can try out all of the amazing lip gloss colors, the matte lipsticks, the Lawnard lippies are included. There are some of the box sets that are back here. We ordered a second round of them. Some of those still exist. So if you know someone who missed out when these went on sale, it is time to get them on sale for the holidays. They are incredible gifts and they are $36.75. So you can go check that out at gerardcosmetics.com. We will have links for you down below. Also, in the US, free shipping over $25. There is worldwide shipping. Free international shipping is over $75. So if you pick up a couple of things, the Clean Eye Canvas, Eye Concealer and Base, you can pick up the Hair AF, which helps your hair grow incredibly. And they have all kinds of stuff, including a gloss lip plumper and teeth whitening. You can find anything you need, but $25 for free US shipping, $75 for free international shipping. Time to shop for the holidays. Absolutely go check out the Black Friday comes early sale. Everything on the website is 51% off. And do you know what Jen told me about it? It's a preponderance of a discount. 51%, just slightly more than 50%. We love a preponderance of a discount. These are my favorite glosses. You see me putting them on everywhere. When I was at Vid Summit, I was talking about how this is such a great collab. And some of you in the audience busted out your light up lip glosses. And I was just tickled pink. And as always, you know, these are cruelty-free products. You are supporting a small US-based, Lawnard-owned, woman-owned company. And I absolutely love it. I absolutely love it. So, Jen, it's good to see you in the chat. You guys, go check it out. All of the links will be there at gerardcosmetics.com. 51% off the sale. This includes the things that literally never go on sale. So it's time to catch up with those things too. And, you know, stock your stuffings. It's time. It's time before Turkey Day. It's time to stock up on your lip gloss, on your Hair AF, on your clean canvas, on your lip liners. I love them. They are so good. They do not dry out my lips. I could talk about these forever, but I have been using these glosses since this channel really started. Jen Gerard was like, hey, you should try these. And they don't make my mouth sticky when I talk. And I was like, I love this forever. Thank you. I love a glossy gloss that doesn't stick. So good. So good. So thank you, Jen. Be sure to go check that out. Hair AF does work great. You will see lots and lots of positive comments about how well it works. So good to see all of you all. Go check out my collab on sale for the holidays. So if you didn't get it then, it's time to get it now. All right, we have one more quick bit. One more quick bit. We have one more quick bit, and then we've got some news to deal with. All right, let's do our second quick bit because we can't not. Because a lot of you tagged me in this. When I see myself tagged and then it blows up my DMs, I know the law nerds want to talk about it. I'm gonna have to put up a poll. Law nerds, what is this? Gwyneth Paltrow ski trial musical to debut in London? Do I need to come report on this? Do I get an invite? Who's in charge? Who is in charge of this? Where is my invite? I will try the caterpillar cakes, and I finally have my passport. Why? Why is this happening? What is going on? For all of you that sent me this, thank you. For the musical, you have Paltrow and Sanderson. Paltrow is holding a candle, says this smells like a lawsuit, mocking the vagina-scented candles. Gwyneth Paltrow ski trial musical to debut in London. Gwyneth Paltrow's legal team. I need to know. Wait, what? I need to know what Gwyneth's lawyers think of this. I'm gonna have to message some people. I got questions. Gwyneth Paltrow's legal battle with a skiing optometrist is getting. Was he an ophthalmologist? Is getting the musical treatment. Gwyneth Goes Skiing is set to debut in London this December from self-described Harbingers of Queer Chaos, Awkward Productions. I'm here for all of it. I'm here for the Harbingers of Queer Chaos. I'm ready. I'm ready for the chaos. Bring me the chaos. I need to ask James. Look, if this musical does not have a song called You Can't Keep Your Skis On While Getting Blown, I am going to be disappointed because that absolutely happened in the trial. And I feel like this needs to happen. Gwyneth Goes Skiing is set to debut in London in December from self-described Harbingers of Queer Chaos, Awkward Productions. Linus Carpel stars Paltrow, while Terry Sanderson, the optometrist who collided with her on a Utah ski slope in 2016, is played by Joseph Martin. The show also features original musical by singer-songwriter Leland from RuPaul's Drag Race. You don't keep your skis on while getting blown. Please! Gwyneth Goes Skiing is based on the court trial between Paltrow and Sanderson that took place earlier this year. Sanderson filed suit against the Sliding Doors star after their collision. He originally sought $3.1 million in compensation. Paltrow, who said Sanderson was the one who had skied into her, countersued for $1 and attorney's fees. The televised 2-week trial became a viral hit and saw clips from Paltrow's testimony turned into memes. Including the moment after the crash when she screamed at Sanderson, "You skied directly into my effing back." The jury ultimately found in Paltrow's favor. She's the goop founding, door sliding, Shakespeare loving, consciously uncoupling Hollywood superstar. He's a retired optometrist from Utah. In 2016, they went skiing. Reads the log line for Gwyneth Goes Skiing. I mean, it's a great log line. I need to put up a poll real quick. Do we need this? Yes, no, here for the laughs is trial. Trial is theater. All right. I think I spelled that wrong. Whatever. So I put up a poll. On the slopes of Deer Valley, their worlds collided, and so did they, literally. Ouch. 7 years later in 2023, they went to court. Double ouch. This is their story, kind of, not really, but also it's at Christmas. I really hope this is some kind of adult humor raunchy take on a Lifetime movie made out of Paltrow and Sanderson. The show at London's Pleasance Theatre, which runs for 10 days, damn it, that's quick. From December 13th, we'll see audience members participate as the jury. I can't I get on a plane? It isn't the first celebrity trial to be dramatized in recent years. The legal battle between British soccer wives Colleen Rooney and Rebecca Vardy last year has been the subject of a stage play, TV drama, and multiple docuseries, including the most recent Colleen Rooney, The Real Wagatha Story. I have questions. Karp is currently starring as Princess Diana in Awkward Productions' staging of Diana the Untold and Untrue Story, described as the most unhinged piece of theater in existence by the website Broadway Baby. Everything about this sounds amazing to me. Everything about this sounds amazing to me. Y'all, I need to call Dr. B. Dr. B! I need to go to London to eat cake and watch a musical. Okay. Thank you all for tagging me in this. I don't know how I feel. Like there's a part of me that loves, look, you know I love British humor. There's a part of me that's like here for taking the piss out of whatever. And there's a part of me that worries about the judges that are like, this has all gone too far. The courtroom isn't theater. The courtroom is most definitely theater. Mm-hmm. But there's also a worry, right? That the judges who don't want courtroom cameras and the rest of it will use stuff like this to shut down cameras in the courtroom. So that's always my worry. It's always my worry that this will be used to shut down cameras in future court. This is absolutely protected speech. No question about it. No question about it. EDB at Custom. What brings you to England? The Gwyneth Paltrow trial musical. Yes. 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 I will make sure that Dr. B helps. Lawyers give monologues that improv based on. Yes, basically 100% a theater in courtrooms. Just watch Putin the courtroom drama. And that's what we're going to next. You can't unring that bell. Courtrooms need views. I think courtrooms need transparency. Agreed. EDB, how mad is Poot that no one made a musical starring him yet? No one made a musical starring him yet. And if they do make a musical starring Poot, it will have to involve him waving guns at the audience because, not real guns, prop guns, but still. Because that was a central part of Poot's trial. Just wild. Just wild. I feel this is a good example of just because you can doesn't mean you should. Totally a business expense. I think so. I want to see Poot twirl. I think if they did Murdacity the musical, it would be. I don't know. Dusty said, reminds me of Chicago. Most trial reminds me of Chicago. But those were fictional tales. These, I don't know. I don't know if theaterifying real trials is what it is. But this trial is done. The appeals are done. This is just done. This is done. So at least it's done, I guess. Let's go talk about Murdaugh. We got a lot to talk about today. All right. Anne-Marie's like, land the plane. We're done with quick bits. Anne-Marie's like, we're done with quick bits. I do need a You Don't Get Blown With Your Skis On song in this musical. We need. All right, chat. It's time to move on to all of the Murdaugh replay crew. Thank you for those of you just hitting the timestamps. It's time to go talk to Murdaugh. You know how I feel about breaking news. However, stuff happens while we're streaming. And when stuff happens while we're streaming, when it is on topic with what we're streaming, we're going to cover it. All right. So let's shift into our main topics for the day. We're headed to South Carolina, folks. Miguelina, we can go ahead and end that poll. Thank you so much. All right. Let's do a road so far of what's going on with Murdaugh. Murdaugh was convicted of murder of his wife and his son. That case is pending appeal. While that case was pending appeal, before the transcripts were in, before the briefs were filed, Murdaugh's legal team filed a motion to stay or pause the appeal so that they could make a motion for new trial. A motion for new trial would go back to the trial court and be heard by the trial court judge, Judge Newman. They asked for a new motion for new trial to be heard based on alleged jury tampering. They accused the clerk of court, Becky, who wrote a book about this case, of tampering with the jury, and they included affidavits from some jurors in their motion that we covered when they asked for the stay of appeal. So that is their motion for new trial. They have since filed that motion for new trial before the lower court, Judge Newman. The prosecution has since responded. We're covering that response today. What the prosecution has to say about whether or not there was juror tampering in the Murdaugh murder trial. The appeal is paused until this is resolved. Once this is resolved, the appeal will resume depending on what happens in the lower court. If the motion for new trial is denied, then the appeal will resume and they will make their appellate briefs and arguments. If the motion for new trial is granted, then there will be a new trial on the murder case. So that is that part. While this is going on, Murdaugh still has a number of financial crimes cases going on at the state court. He also has a number of cases going on federally that he has pled to. So there are federal prosecutions, there are state level prosecutions that are still ongoing. Well, all of this was happening. Poot and team filed a motion to the Supreme Court of South Carolina asking them to remove Judge Newman from consideration of the motion for new trial based on the Courthouse Becky stuff and from future trials. They say that Judge Newman already made known how he feels about Murdaugh's guilt and that he does not appear to be a fair and unbiased judge when it comes to Murdaugh. So they want to have Judge Newman removed from considering the motion for new trial and from future trials. One of those future trials is set for the end of November 2023. That is the motion regarding the alleged theft from Gloria Satterfield. It's hard for me to say alleged theft from Gloria Satterfield because he admitted it when he testified in the murder trial, but that case has not gone to trial yet because they don't want him to plea. Here's why. When you get convicted, I think it's 3 of the types of financial crimes Murdaugh is being charged with, you can also get a life sentence. So if anything ever happened to the murder conviction or the sentencing, you would still have another life sentence for Murdaugh. So this is why I believe they are going through the state level prosecutions, or at least some of them, because they want to have multiple life sentences on Murdaugh so he never gets out. So while all of that is going on, we have another motion from Poot et al. Regarding the team, or regarding the trial that is starting at the end of November, saying that they are having issues with picking a jury and they need to either change venue or delay the trial. That's where we're at today. And so today we're going to cover new news regarding Judge Newman. We are going to cover the state's response about Courthouse Becky and the jury tampering. And we are going to cover the defense's motion to delay the trial set for the end of the month. Those are the three things we're covering today. We are going to get into all of it. We're going to start with Judge Newman recusing himself. So let's go to that. First, this is the kind of breaking news that I will occasionally cover because this is breaking news regarding the thing that we're talking about today. Let's talk about Judge Newman. This is coming from Fitz News, a local news outlet in South Carolina. We love an independent news outlet. Murdaugh saga. Clifton Newman stands down. Judge Newman has requested that a new judge be assigned to handle the post-trial motions involving the murder charges. That's the Courthouse Becky stuff. That's just the Courthouse Becky stuff. This is part of what the defense asked the Supreme Court for, not all of it. Judge Newman still has a hearing tomorrow. I imagine tomorrow they're going to ask him to recuse himself from all of the cases, not just this. But Judge Newman might be a witness in the witness tampering stuff, and it is his clerk of court. I'm not mad at this decision. Let's keep reading. Let's keep going. South Carolina Circuit Court Judge Clifton Newman has voluntarily recused himself from hearing further motions tied to the double homicide charges against convicted killer Alex Murdaugh. Murdaugh was convicted in March of murdering his wife and son at Moselle in Colton County. This is a summary of what happened. I already did that. Newman was set to rule on whether or not Murdaugh should receive a new trial, but now that responsibility will fall to another judge appointed by the Chief Justice, Donald Beatty. Newman's decision to stand down was revealed in an order issued on Thursday, November 16th by the South Carolina Supreme Court. I looked at the South Carolina Supreme Court docket yesterday when I was prepping cases. I had not seen this published yet. I was looking for it yesterday too. I was. Which earlier this month had been asked by Murdaugh's attorneys to assign a new judge. And that was the request that Newman was unable to sit in judgment over the motions for two reasons. He was a potential witness to the jury tampering against the clerk of court, and he made extrajudicial comments in the aftermath of the guilty verdict. Based on Newman's decision, the Supreme Court denied the motion, arguing that the request is now moot. Judge Newman has requested that a new trial be assigned to handle the post-trial motions involving the murder charges. So that's it. Here's the order. We love it when the order is here. Here we go. Supreme Court of South Carolina, Murdaugh versus Newman on November 1st. Petitioner Richard Alexander Murdaugh filed in this court's original jurisdiction a petition for a writ of prohibition seeking an order prohibiting the Honorable Clifton Newman from adjudicating petitioner's motion for new trial that is currently pending in the Court of General Sessions in Colton County from presiding over future trials of indictments against the petitioner. Petitioner also filed a motion to stay all trial court proceedings pending this court's ruling on his petition for a writ of prohibition. On November 6th, 2023, the state filed a return in opposition to the motion to stay, indicating petitioner faces 101 financial and narcotics charges, 13 of which are presently scheduled for trial beginning November 27th in Beaufort County. The motion to stay is denied, and the trial scheduled to begin on November 27th shall go forward as planned. We'll see what happens tomorrow. The writ of prohibition is denied as to future trials of indictments against petitioner. This is why I like to read the court motions. This is why. I like to read the court motions because this makes it very clear, the article did not. This makes it very clear that the court is not just saying this is moot. The court has also denied the motion with regard to future trials. The article made it seem as if they're just like, oh, it's moot. He recused himself. There were two parts of this petition. Both parts are important. So now we've got the full story. Both parts. They're denying the motion to stop Newman from hearing cases going forward. And the rest of the motion is denied as moot because Newman recused himself from just the post-trial, new trial motion on the murders. So, the writ of prohibition is denied as to future trials of the indictments against petitioner. As to petitioner's pending motion for new trial, the writ of prohibition is denied as moot. Judge Newman has requested that a new judge be assigned to handle the post-trial motions involving the murder charges. I think that's appropriate. So, I don't know if it's a journalist flub. I think that journalists see the story headline first. I've never worked as a journalist, and don't necessarily pick up on the same things a lawyer finds important. So I find both parts of the petition important because I cover all of the legal documents. So I want the legal documents, and I appreciate that they attach the legal documents to it so we can go. So it's, I find, again, it's easier to just go directly to the document and see what is said. And I'm really appreciative that FitzNews attached it. So the Supreme Court has, just in summary, the Supreme Court has denied the motion that Judge Newman cannot sit on future cases. Remember, Poot and company argued that he had already made comments to his college and comments to the media and comments on television that he felt Murdaugh was guilty, and that Poot et al. Argued showed that he could not be a fair and impartial judge going forward on future cases. The Supreme Court disagrees and denied it. As to the motion for new trial, the Supreme Court said that is moot. He's already said it should be assigned to another judge. And I think that's appropriate. So I'm here for it. So I'm here for all of it. So, all right. Let's see. Courtney said, I appreciate this insight. I studied journalism and wrote for a newspaper for a time. The issue is trying to get the scoop. So sometimes we run to publish with the headline and go back and make corrections and updates. Fair enough. And also, that's the big 3 line, is that he recused himself. But he didn't recuse himself for everything, and there's still a hearing tomorrow. Question, is the motion for new trial considered part of the affected motions? The motion for new trial only deals with the Courthouse Becky stuff. So only that. So Joe Jersey, question, isn't Judge Newman retiring? At some point, he's reaching the age where he's forced to retire. I don't know if they can allow him to sit in on these cases he's still handling. Did Courthouse Becky lose her job? I don't think so, because she kind of messed up. Well, we're gonna see. We're gonna see what happens. So, Judge Newman has recused himself from the motion for new trial. What we're going to do next is all of the other Courthouse Becky stuff. Hold on, let me make sure I keep that and keep that up. I'm going to go pull up should we do the Courthouse Becky stuff next? I feel like that's what we need to do next. So let's do that. Let's do Courthouse Becky stuff next. And then we will do the motion for delay and change of venue after that. So Courthouse Becky first, delay second. Yes, great. Thank you, chat. You help me make decisions, and I appreciate you. Courthouse Becky, who wrote a book, is being accused by the defense of tampering with jurors. The defense included several affidavits. Some of them are just retellings of conversations and not actual affidavits, saying that jurors saw Becky having one-to-one conversations with jurors, that they accuse her of telling jurors not to believe anything the defendant says. They accuse her of improperly tampering with a witness. The allegations are staggering. They are appalling. And if they are true, it is a huge problem. For me, if they are not true, it is equally appalling because they have made huge, huge allegations against someone. And if those are not founded, that is a big problem. So we're going to see how the state responds to this. The defense is trying to get Murdaugh a new murder trial. So with all of it, did I say tampering with a witness? Juror tampering. We're always talking about juror tampering. If I said witness, I have misspoken, because witness tampering is often what happens. And on Tuesday, we did talk about the walk the dog letter. So that is what is lodged into my brain at the moment. So this is the state's response to the jury tampering motion for new trial. And that is what we are going through today. It is 48 pages long. We are going to go through as much of it as we can. And then we're going to go through the other new trial motion. All right. Are we ready? Let's go, team. Let me do that, because it's a little bit easier. This is the state of South Carolina versus Murdaugh. State's response to defendant's motion for new trial and state's motion to strike. But in more important news, Suika is addicting. Wait. The magic to get it is shake it to. Did you say 100? No. 11,540 or 1,540? Because 11. Yes, get it. 30,000 is my goal, or 3,000 is my goal. 11,000, I don't even understand. But if it's 1,540, that makes sense. 3,000 is always my goal on Suika. All right. Squirrel. Yes, I squirreled. I squirreled. I'm going to have to try shaking it. We're going to have to try that. Like a Polaroid picture. Okay. My son and I call it fascinating fruit. My husband was like, what are you talking about? I'm like, Suika. Yeah, I 100% blame Ludwig. I just brought that to y'all. He definitely spots the trends in the trends in the gaming space. I'll just do the law stuff. All right. Murdaugh was convicted for the murders of his wife, Maggie Murdaugh, and son, Paul Murdaugh, by a jury before this court in Colton County, March 2nd, 2023. This court sentenced Murdaugh to consecutive sentences of life without parole on March 3rd. It was the craziest, fastest sentencing I've ever seen. They're like, everybody ready to sentence tomorrow? Yep. The only option was really life, but they were all like, yeah, let's go. Let's go. Sure. After filing a notice of appeal and during the pendency of that appeal, Murdaugh filed in the Court of Appeals of South Carolina on September 5th a motion to suspend appeal and for leave to file a motion for new trial. On October 17th, the Court of Appeals granted the request to hold the appeal in abeyance, to pause it, and remand the matter to this court to permit Murdaugh to file his motion pursuant to Rule 29B, SC Crim P, South Carolina Criminal Procedure. Murdaugh so filed with the Colton County Clerk of Court on October 27th, 2023. We've gone over that motion. This is the response. Dun dun. Murdaugh broadly claims that he is entitled to a new trial based on allegations that the Clerk of Court, Becky Hill, improperly attempted to influence the jury's decision. In support of his claim, Murdaugh offers affidavits from one juror who participated in deliberations, one who was removed for dishonestly concealing her own improper communications about the case. Oh my. Oh my. That's an insane score, SVDS. That's 11,540. I can't even wrap my brain around me trying to get a score of 3,000. That's insane. I mean, the devil works hard. You work harder. Amazing. Absolutely amazing. And thank you. My brain paused. So thank you for clarifying. I'm so jealous. How many watermelons is that? Do the watermelons combined if you get 2 full? Like, what's after that? I'm so confused. In support of his claims, Murdaugh offers affidavits from one juror who deliberated, one who was removed for dishonestly concealing her own improper communications about the case. I have questions about that. And 2 hearsay affidavits from his counsel's paralegal. Fair. Murdaugh additionally advances a sweeping conspiratorial theory about wholly irrelevant Facebook posts with scant evidence to support it. The state responds as follows. Law and procedure. Colorable claims of after discovered improper external influence on a jury may necessitate a judicially conducted inquiry to confirm the validity of the verdict as free from external influence, through which defendant must show actual prejudice. That's a long statement of the law. This is also a terrible photocopy, and I hate it. The law permits, but skeptically receives, motions for new trial based on after discovered evidence, and never does the law permit highly motivated convicts. Damn, they're just like, wah, 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 wah. And never does the law permit highly motivated convicts to put their own jury on trial. That is a strong sentence. Quote, there can be no doubt that motions of this sort should be received with the utmost caution because, as it is said by a learned judge, is it Judge Learned Hand? Which learned judge? Why are we not naming the judge? Is this like my learned friend? As it is said by a learned judge, there are but few cases tried in which something new may not be haunted up, and also because it tends to perjury. That is a case from 1934, State v. Mathis, quoting State v. David. Quote, it would have a mischievous tendency, after all the evidence on the part of the state has been fully disclosed, to allow one with his life in danger an opportunity by the assistance of his confederates to procure unprincipled witnesses to contradict the evidence on the part of the state and thereby defeat the ends of justice. Same case, quoting State v. Harding. State v. Harding is a 1800 case. We are, again, back when the Magna Carta was written. We have gone back in time because it's well-settled law. Look, you don't get to put the jury on trial. The defendant who has been convicted has a motive to maybe skew their perception of things. It goes on to say, nevertheless, criminal defendants have a right to a fair and impartial jury, and private communications or contact with jurors during a criminal trial about the matter pending before them may necessitate an evidentiary hearing and, if the defendant can show actual prejudice, a new trial. So for the chat that was asking, are there non-learned judges? David in the chat has identified that correctly. You continue to read that correctly. The texting judge. There are, in fact, unlearned judges. Brielle, that's hilarious. Emily has a mischievous tendency to procure fruits. All the fruits. I want to see the evidentiary hearing on this. I think that's what needs to happen. I just think you have to have an evidentiary hearing at this point. And if the allegations are false, you may need to have some motions for sanctions. But the boundaries of that are zealous advocacy. So there are boundaries to what you can do. There are boundaries within zealous advocacy. Nevertheless, criminal defendants have a right to a fair and impartial jury, and private communications and contact may necessitate a hearing. The court has long held that the remedy for allegations of juror partiality, opposite of impartiality, is a hearing in which the defendant has the opportunity to prove actual bias. The burden of proof at this motion for new trial, if an evidentiary hearing is granted, is on the defense. The defense has to prove that there was bias. And this is a very difficult thing to prove. Remember back in the Maxwell case where a juror hadn't disclosed their own incidences of abuse similar to what was being alleged in that case, and the court did a whole hearing and found that there was no prejudice. And I was like, how are you not granting a new trial on this? And the court's like, no. The standard is very, very high. Sometimes for me, it is uncomfortably high because I'm like, I don't like it. And the court was like, no, the juror said they could be fair. I saw a great question in the chat. Where did it go? Robbie said, question, I thought when you said my learned colleague, it was a slight insult. It depends on the context. Learned judge is different. This is a case from, what was it, 1830 something or 1930 something. So it doesn't have the sarcasm. Now, there are times that, as my learned colleague said, can be used with sarcasm. It is the way, with all due respect, does not always indicate respect. So it depends on context and the attorney. When I say it, it's generally snarky. I think when Ian says it, it is also generally snarky. So let's continue on with this case from 1954. This is the standard of proof, actual bias. These are cases unanimously declining to adopt a different standard, and it's presumptive prejudice standard. Presumptive prejudice means if there's anything you presume it's a problem versus the defendant having to prove it's a problem. We are now in the defendant has to prove it's a problem. Not every inappropriate comment by a member of the court staff to a juror rises to the level of constitutional error. Were that the rule, few trials would be constitutionally acceptable. Well, that's unacceptable. It's like, this is the judicial, shit happens. But also impermissible comments can be, how are you guys doing? Do you need the temperature changed? Sometimes those can be problems. Additionally, jurors are presumed to follow the law as instructed to them, to include instructions of what constitutes proper evidence to consider in deliberations, and such instructions are usually deemed to have cured any erroneous exposure to improper evidence or argument. Well, we just told them to ignore it. That's fine. Where a defendant knows or could have known of a constitutional issue at the time of trial, the defendant is obligated to timely rise the issue to the court's attention or else waive it on future appeals. Footnote 1 is very long. To whatever extent Murdaugh may insist on Reamer as controlling, federal courts are hardly consistent in interpreting and applying it. Compare United States versus Frost, holding that not all communications with jurors warrant a hearing and that the defendant must show that an unauthorized contact created actual juror bias. United States versus Johnson, if a defendant makes a threshold showing of a credible allegation that an unauthorized juror contact was made, they are entitled to a rebuttable presumption of prejudice and an evidentiary hearing to determine what actually transpired and whether that actual happened and whether what actually happened was harmless. The United States Supreme Court's statement in Smith v. Phillips that defendant must prove actual bias abrogates Reamer to whatever extent it suggests otherwise. See Smith at 215-16. Remedy is a chance to prove actual bias, not implied bias. Finally, a significant portion of the Supreme Court of the United States has suggested that Reamer pronounces no constitutional rule at all. See e.g. these other cases. Not only did Reamer not clearly establish the Sixth Circuit's any colorable claim rule, it is not even clear that Reamer established any constitutional rule. Oh, they're arguing that it's dicta. Chat's like, this is not a footnote. It's a leg note. It's a lot of a note. Whoever came up with that in the chat, I'm sure I missed the original one. That is hilarious. Darkfire 0, more like a leg note, really. Facts. Chat, y'all are funny. Footnote 2, Murdaugh also cites Cameron, but in that portion of the opinion which does not state the legal standard, but rather quotes a portion of the Fourth Circuit Court of Appeals opinion inconsistent with the standard acknowledged by Cameron and more subsequently clarified in Smith, as most recently in Green, Murdaugh must show both that the alleged improper communications occurred and that jurors were actually biased as a result. So this is the court or the AG smacking down the legal research and saying, no, all of these cases show that the standard they want the court to adopt is not the standard. Where a defendant knows or could have known of a constitutional issue at the time of the trial, the defendant is obligated to timely raise the issue. They've argued that before. Where a defendant does not learn of a constitutional violation until after trial, the defendant is obligated to seek relief within 1 year of the actual discovery of the violation, or when it could have been discovered through reasonable diligence, or within 1 year of the sending of the remitter from appeal. Footnote 3. Murdaugh's motion is filed pursuant to Rule 29B, which pertains to quote-unquote evidence, typically conceived as facts which would have been presented to a jury at trial relevant to guilt or innocence. So they're saying that the rule that they're filing under is evidence, not all, is evidence of things that would be presented at trial, not evidence of juror wrongdoing. Sorry, I caught this footnote from Terry Dixon. It caught my eye. Court TV is reporting Judge Newman recused himself from the Murdaugh trials. False. We talked about that earlier. Judge Newman has recused himself from hearing the motion for new trial, and that is it. So if they are reporting that Judge Newman has recused himself from everything, they are improperly stating that, which is why we covered the court filing earlier. You got to read the court documents. Not you, chat. You're here with me. We're reading the court documents, but got to read the court documents. Maine Nana Bear said, so if the jurors say that Becky's comments didn't sway their decisions, does that then mean there is no prejudice? Yes. Yes, it would. I still think we need, at this point, we're not through the state's response yet. Here's where I'm at this point. We need an evidentiary hearing. We need a hearing. We need a hearing. That's where I'm at. We'll continue and see if I change my mind. But right now, I'm still at, we need a hearing of this. A prima facie showing that defendant is entitled to relief is necessary before an evidentiary hearing can be granted. So the defendant has to meet the threshold showing that there even should be a hearing. I still feel like there should be a hearing. A jury poll may cure any procedural irregularities and confirm that each juror approves of the verdict. That was done in this case. They polled the verdict. They polled the jury of the verdict at the end of the case. If a prima facie showing is made, the resultant evidentiary hearing is a strictly limited, judicially conducted affair, particularly as concerns examination of the jurors. This is what happened in the juror issue in the Maxwell case. Can I say the full name? No, this whole video got suppressed. YouTube gets squirrely. The competency of jurors as witnesses is strictly circumscribed by the rules of evidence. Quoting the rules of evidence. Upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the juror's deliberations or to the effect of anything upon that or any other juror's mind or emotions as influencing the juror's assent to or dissent from the verdict or indictment or concerning the juror's mental process in connection therewith, except, this is the part we need to focus on, except that a juror may testify on the question whether extraneous prejudicial information was improperly brought to the juror's attention or the jury's attention, or whether any outside influence was improperly brought to bear upon any juror. The jurors can testify about undue outside influence, improper extraneous prejudicial information. They cannot be made to testify about their thought process, what they said, what shifted what they were doing. It can't go into their thought process. It can only go into extraneous prejudicial information or improper outside influence. That's it. It goes on to say, nor may any juror's affidavit or evidence of any statement by the juror concerning a matter about which the juror would be precluded from testifying be received for these purposes. So they're saying this has to be limited. I wonder if this is where they're getting into their motion to strike. Both the Supreme Court and the Court of Appeals commended the trial court's, quote, deft handling in Green for the process it followed in investigating its own allegations of improper communication between a bailiff and a member of the jury. The trial court questioned each juror and the bailiff, which proved, quote, there was no reasonable possibility that the bailiff's comments influenced the verdict. More specifically, the Honorable Donald B. Hawker, immediately after publishing the verdict, cleared the courtroom of all present, save the lawyers involved in the case, the clerk, and the judge's staff, then brought out each juror individually and pulled them on the record, asking the following questions. Was your verdict guilty on both charges, and is that still your verdict? Was your verdict based 100% on the testimony, evidence, and law presented at trial? Was your verdict influenced in any matter by any communication with any of the bailiffs or any other persons outside of the 12-member jury? Did you have any communication with any of the bailiffs or with a third party not part of the jury? And if so, please relay to the court what those communications were. Footnote 4 and footnote 5. In the present case, we are now many months documentaries and juror interviews removed from the verdict. And so the question of, is that still your verdict, is not a probative one. And that comes from State v. Green, the record from that case. Similarly, in State v. Kelly, upon learning that a juror had introduced, quote, a religious pamphlet concerning God's view on capital punishment, to the rest of the jury, the trial court individually questioned the jurors to determine who, if anyone, had read the pamphlet and what information was contained in the pamphlet. So one juror was trying to tell them that God was against capital punishment and to influence their decision. Okay. The trial court also conducted the questioning in State v. Bryant using questions submitted by the parties after they learned of improper contact with jurors by an investigator. Thus, the established practice is that when concerning allegations of inappropriate communications, the court, not the defense attorneys, the court should voir dire the complaining juror, each juror who engaged in the final deliberations, and the alleged improper communicator, in this case, Courthouse Becky, with a mind to at least one, whether the communication actually occurred, and if so, its context and substance. 2, the number of jurors exposed to the improper communication. 3, the weight of the evidence properly before the jury. And 4, the likelihood that curative measures were effective in reducing the prejudice. The trial court then brought each juror out separately for individual questioning. That might be what needs to happen here. But for proposed questions submitted and subject to judicial pre-approval, the court should not permit interrogation of the jurors by the parties or their attorneys. Agreed. The court should do it. And this is the part Newman has recused himself from. Let another judge handle this part. Fine. Jury duty is a cornerstone civic duty. A needless exposure of jurors to litigative stress and impeachment by zealous attorneys, particularly in a case with this level of public exposure, can only serve to further discourage citizens from willingly participating in this duty. This is how I felt when Team Heard was going after the jurors too. Stop it. Trial. Near the end of Murdaugh's trial, separately sourced reports of improper discussions and social media posts were brought to the court and investigating, resulting in the excusal of juror 785, who now raises allegations he or she expressly denied to the court when examined. Oh, shit.
That's going to be a problem. If they've changed their statements, it's going to be a big issue.
Portions of the trial transcript illuminate or are otherwise relevant to resolving the allegations now raised by Murdaugh. The state excerpts and summarizes them as follows. Great. 1. The court consistently instructed jurors not to discuss the case and to only consider the competent evidence presented in the courtroom. Once the jury was selected, the court promptly admonished the original 18 jurors that, quote, "It is improper for you to know that you are not to discuss." Important. Damn it. I can't read today. "It is important for you to know that you are not to discuss the case with each other or with anyone else, and not to endeavor to find out any information about this case other than what you will see herein, the jury, in the courtroom." After a break during the court's preliminary instructions, it's again emphasized the importance of not discussing the case and accepting only evidence in the courtroom. And that's the judge's instruction. We heard it day in and day out. Consistently throughout the trial, and even at points during jury selection, the court reminded and admonished jurors not to discuss the case. All of these cases. The state's really trying to make a point. That could have been a footnote. I mean, it would have been a half a page footnote, but they're like, literally some law clerk, I imagine, went through this and found every time the court admonished the jury, bring the jurors. In its charge to the jury at the end of the case, the court instructed the jury they were to accept only the evidence presented and that they were the sole judges of credibility. You are to consider only the testimony which has been presented from this witness stand. This witness stand. With this jury. This witness stand. Along with other exhibits that, as evidence presented during the trial, any other evidence or exhibits which have been made a part of the record you may consider along with any stipulations made by counsel. You are also the judges, the sole judges of the credibility. That is the believability of the witness who have testified and the evidence offered. It becomes your duty as jurors to analyze and to evaluate the evidence and to determine that evidence which convinces you of truth. In addition to the dozens of times the court told the jury, do not discuss the case prior to the close of evidence, the court again instructed the jurors, if your deliberations necessitate an overnight break, you may use these electronic devices as necessary, but you may not use them to communicate with anyone about the case until it is over. Tuxedo Cayman. That's no citation, Moon. That's a citation, battle station. That's not a moon. All right. Let us keep going. The court further instructed the jurors that an overnight break in deliberations was a possibility, and if they so broke, that they were not to seek information and should avoid the use of electronic devices. Not that they were going to be like swept away to a hotel and like kept away from everybody. Certain statements attributed to Clerk Hill, Courthouse Becky, by juror 630 closely resemble statements made in court by the state. The parties made their opening statements on Wednesday, January 25th, 2023. It was such a long trial. Did that really start almost a year ago? The state, as part of its own opening statements, advised the jury, you're going to see video statements of Alec Murdaugh. You're going to see a body-worn camera of him at the scene when law enforcement arrives and hear what he says about that night. You're going to hear 3 recorded statements on video that he gave with law enforcement, and you're going to hear how things progressed and what he says he did that night. Watch those closely. Watch his expressions. Listen to what he's saying. Listen to what he's not saying. Use that common sense. Does this seem right? Or does something seem a little off? Does something seem a little off about this? The jurors so complained and were closely attentive throughout trial. The jurors so complied and were closely attentive throughout trial. At the end of the initial closing argument, the state implored the jury not to let Murdaugh fool them. This is what he did. This is what he did right here. This defendant, on the other hand, has fooled everyone. Everyone who thought they were close to him, everyone who thought they knew he was who he was, he's fooled them all. And he fooled Maggie and Paul too, and they paid for it with their lives. Don't let him fool you too. Very dramatic. Later, the state in its final closing argument returned to the subject of body language while addressing the testimony of Michelle Shelley Smith. Do you think she knew right then? And that's real. That's real. Shelley is real. You saw her. Body language is so important in life. Body language. Mr. Waters was talking about, with the defendant, all of our body language. Did you see Shelley's? Oh, that's a Metters. That's a Metters take. That's from the reclose. That's Metters. When Metters scared the shit out of us during closing. Bubba, come here. I'm still not recovered. My soul is still not all the way in my body from that. The court thoroughly investigated allegations of improper communications by juror 785 and ultimately dismissed the juror for those communications, but gave no weight to the supposed Facebook post reported by the court of Clerk Hill in a conversation which was placed on the record. Egg juror was dismissed for other reasons. On Tuesday, February 28th, 2023, after the conclusion of the replay examination of Kenny Kinsey, the court initiated an in-camera hearing regarding an email that raised juror concerns. In sub and substance, the email represented that the unidentified author heard from an unidentified coworker. Oh, Jesus. I remember this. That the unidentified author heard from an unidentified coworker that said coworker's landlord was a juror who said Murdaugh was innocent. And that said juror, quote, works at the monkey farm. I remember this. Murdaugh's counsel advised the court to disregard the email as mere noise in a high-profile case. Your Honor, I heard from my coworker who heard from their landlord. To disregard it as mere noise in a high-profile case. But the state expressed concern that the allegation of a clear violation of the court's instruction to the jury and noted there were still alternate jurors. Counsel Griffin speculated without support that the email was an orchestrated effort to get the juror removed. Who would know that juror? The monkey farm is an animal testing lab facility. Did they ever say why the egg juror was dismissed? We're getting into it right now. The court then informed the parties of its exchange with Clerk Hill, who had evidently learned of the email. The court, okay, after I showed you all this email, we came back here And the clerk came in and asked whether we had heard the same thing about the juror. And we were in the midst of trying to figure out who the juror was and that this pertained to, since it did not indicate a juror number, it just said someone who worked at the monkey farm. So the clerk then said she was reading her Facebook messages over the weekend. Gabby, help me out with the fact. Did she say over the weekend? Law clerk. This is Gabby, who was excellent. She said on Friday she was going through her timeline on Facebook and saw a post from this man who was supposed to be the ex-husband. The court, yeah, ex-husband. The ex-husband of this juror. And that his post was that she was discussing the case with various people. I think that's what Becky said. Clerk, correct. The court. We asked Becky the clerk, to make a copy or get a copy of the Facebook post or the Facebook that she was the post that she was referring to. She came back a little while later and said it had been deleted by this ex-husband that she printed out what remains on his post, which was him stating that he posted an ugly post, which he deleted. Substance of Facebook apology post, humorous exchange between Mr. Metters and Mr. Harpootlian. Excuse me, state. You cannot just redact out the humorous exchange between Metters and Harpootlian. Give us something. Give us the humorous exchange between Metters and Poot. Come on. We sat through 6 weeks of a 3-week trial. We've been so kind. We've watched the entire thing. Give us the humorous exchange. I want to know what it is. And was this before or after Poot said tempting and waved a gun at everybody? Damn it. I missed the humorous exchange. I want it. Redacted. The court. But the clerk said that she read the post where he was discussing that his ex-wife, the juror, had been discussing the case. Now, it was just very curious. We were talking about the email, and the clerk came in and was talking about a Facebook post, and she said that the juror works at the monkey farm. I was here trying to figure out what juror works at the monkey farm, and this juror, number 785, works at the business name, Yamancy, South Carolina, which is the monkey farm. Discussion of what the monkey farm is. Okay. That's also redacted. I don't know. The court and the clerk said the juror that they were posting about was the juror who works at the monkey farm, and this email referenced the juror who works at the monkey farm. So the court was sitting there saying, we've got a Facebook post and an email, and they're both referencing a juror that works at the monkey farm talking. And the email is like, hey, my coworker's landlord was saying this juror has been talking about it. And the Facebook post they thought was from the ex-husband. I think the Facebook post is sus. Counsel Griffin suggests bringing in juror 785, and the court agreed and noted its desire to also hear from Clerk Hill, who was not present at that time but had mentioned the Facebook post earlier in the day. After some discussions by the parties as to appropriate procedure and the desire of the complainant to remain anonymous, the person in the email, as well as other trial procedural matters, the court conducted an in-camera examination of juror 785, quote, to discuss any conversations that juror had with anybody about being on jury duty. As part of a brief discussion about a missive allegedly posted to Facebook by juror 785's ex-spouse, juror 785 noted that Clerk Hill had alerted her about the post. This is a problem for me. The court specifically followed up and asked the clerk, so has she, Courthouse Becky, discussed the case with any of the jurors? Has the clerk discussed anything about the case with anyone on the jury? Juror, not that I'm aware of. So at that point, the juror said, at that point, the juror is answering the court that they don't believe the clerk of court has discussed the case with anyone, and that would include this juror, but has discussed the Facebook post. Counsel Griffin, then satisfied, accepted Juror 785's explanations and argued that they remained a competent juror. Upon the state's expressed desire to know the identities of the persons who reported the improper contact to the court again summoned Juror 785 and elicited additional information sufficient to identify the persons with whom the juror allegedly had the improper conversation. Two of Juror 785 tenants, hereafter referred to male tenant and female tenant, shortly after 9 p.m. that evening, agents with SLED located the tenants, interviewed them separately, and prepared a memoranda and recordings reflecting the interviews. So it starts to get into what's alleged by the defense of like delivering an appliance or something. On March 1st, 2023, the 27th day of the trial, the tenants met with one of the assistant deputy attorney generals, David Fernandez, and Deputy Attorney General Donald Zelenka, and executed affidavits consistent with their statements to law enforcement the night before, which stated that Juror 785 had delivered a refrigerator to them on Saturday, February 18th, and briefly discussed the case. That's why the juror was let go. Because two individuals were like, yep, they absolutely talked about it. After the jury view and the state's initial closing, the court convened another in-camera hearing to review the affidavits and examine Juror 785's statements. The court asked the male tenant about his affidavit, and so they brought in the tenants as well. The court asked the male tenant about his affidavit, and he explained that he offered his opinion about the case to Juror 785, who had disclosed their role as a juror while speaking to the female tenant while they were delivering the refrigerator. You shouldn't be doing that. Juror 785 had replied to male tenant that, quote, she hadn't decided either way because it was, it was kind of early in the case, I guess, that she made no decisions if he was guilty or if he wasn't guilty. I mean, it's not the worst statement. The juror should have said, I can't talk about the case, and should never have said that they were a juror. And if they started talking about the Murdaugh case, should have said, I can't discuss that case. The state then reviewed with male tenant his affidavit line by line, and he confirmed it was accurate. When counsel Harpootlian asked male tenant to elaborate on line 9 of the affidavit, in which the tenant recalled that Juror 785 stated that she didn't believe there was any evidence to make her think the defendant was guilty at that time, the male tenant expressed that he took her to mean she had not made up her mind. The court next examined the female tenant. The female tenant explained that Juror 785 disclosed while delivering a refrigerator that they were on jury duty, which prompted male tenant to offer his opinion as to Murdaugh's guilt. Female tenant recalled the juror said, well, I can't talk about it. Shouldn't have mentioned you were a juror. Ever. She said, but as of now, nothing, reasonable doubt could make me say he's guilty. That's an odd sentence. When pressed by counsel Harpootlian as for a direct restatement of as female tenant could muster, female tenant recalled the juror saying, quote, that she could not without, a doubt or whatever, say he was guilty. So the female tenant believed, this fucking game of telephone. The female tenant believed that the juror was saying she was not at beyond a reasonable doubt yet. Juror 785 did not explain to female tenant why she held that position. Female tenant reaffirmed her recollection in the affidavit that Juror 785 indicated that she didn't believe there was evidence beyond a shadow of a doubt or beyond a reasonable doubt that Murdaugh had committed the crimes he is alleged to have committed. That is an expression of an opinion, it seems. After hearing arguments from attorneys for each of the parties, the court noted that, quote, in many cases, typically without any inquiry, this juror would be gone, without anything further. The juror would be gone without any discussion because she's discussing the case and was ordered not to discuss the case. Even if she's discussed it for a very short period of time, she's having a discussion, so much so that the person understands that it shouldn't have taken place, and sent an email. That's why they're dismissed. The court then summoned Courthouse Becky to discuss the supposed Facebook post. We've gone through all of this. I'm going to zoom this. She briefly saw a post Friday in the Walterboro Word of Mouth. The Facebook post still seems sus to me. Clerk Hale, quote, figured the post referred to juror 785 and alerted the court. How did you figure that? No. After some discussion about the feasibility of finding the devil-afflicted suspected ex-husband, that's funny. The devil-afflicted suspected ex-husband, the court asked if the parties wished to locate him. Counsel Harpootlian very clearly declined. I think not, Judge. I think if you would just accommodate me, bring juror 785 in, ask them about the specifics of the conversation. If they say yes, I'll have no complaints whatsoever. The court complied with counsel's request, summoned juror 785, informed them that the court met with the tenants, and asked if the juror could recall anything further about the conversation. The juror acknowledged delivering the refrigerator, and the tenants expressed opinions to her about the trial, but denied expressing any of the jurors' thoughts to the tenants. After discussing jurors' ruse to claim that they were in Facebook jail during the trial and irrelevant particulars of their employment, counsel Harpootlian astutely observed that juror 785 placed their spouse at the scene of the conversation. There's a ruse, and they called Poot astute. What's happening? We've got an astute Poot and a ruse. Juror 785 called their spouse, put them on speaker, and upon brief examination by the court, juror 785's spouse said the juror was talking with my tenant's girlfriend, I think. And I know they talked about the trial, but I don't know to what extent, if you know what I mean. So the juror's spouse said, yeah, they were absolutely talking about it. The juror doesn't want to get in trouble or be off the trial. But the spouse said the juror was talking to the tenant's girlfriend and talked about the trial. Okay. The spouse further explained nobody was saying
Nobody was saying guilt or innocent, but they were talking about some of the facts that had come out in the case. Either way, for real.
The spouse also acknowledged talking if there was any excitement in juror 785's day each evening, but that they did not talk about details. Oh, so they were talking about the case when the juror came home. So the juror came home and was like, this happened in court today. We didn't talk details, but they were like, these lawyers. Yep, nope. That juror needed to be yeeted. Finally, the court granted counsel Harpootlian the opportunity to confront juror 785 directly with the tenant's affidavits, which the juror denied as inaccurate. Once juror 785 was excused, and after a very brief discussion of the witnesses, counsel Harpootlian declared, I'm not going to argue anymore about this. I'm going to defer. It's your call, your judgment. Your Honor, I'm not going to argue with whatever you do, okay? Yeah, because there's nothing you can do. That juror needed to be heated. That juror was clearly having conversations about the case. Even if they hadn't made up their mind about the case, they were having conversations about the case. Facebook post aside, Facebook post sketchiness aside from all of it, they were having conversations about the case. You can't even talk with your spouse about the case when you're on jury duty. You cannot talk to anyone about the case. That's more information than we've had about that exchange. The following morning, March 2nd, after reviewing the video recordings of the interviews of the tenants, the court excused juror 785 from service for offering her opinion regarding evidence received up to the point of and during the conversation with the tenants. Counsel Harpootlian immediately declined to take any exception to the ruling, or affirmatively declined to take any exception. Yeah, there's nothing you can do. They should have made them drag their chair. They should have. Ray said, wow, Poot completely misrepresented what happened with this juror. Here's the thing about advocacy. You need both sides, which is why throughout the entire Courthouse Becky thing, I kept saying, if this is true, this is bad. If this is true. Because advocacy. Juror 785 was summoned to the courtroom, advised of the court's ruling, and upon inquiry about a conversation this morning with Miss Becky, the court emphasized its ruling had nothing to do with anything brought up about the juror's ex-spouse. The juror's possession, to include a dozen eggs, were retrieved from the jury room, and juror 254 was promoted from alternate to the panel. The egg juror. The egg juror. Which we all saw happen on TV. Can I get my eggs? Eggs, look, eggs were like $8 a carton at the time. Absolutely go get your eggs. The jury, which never deliberated with that juror or alternate juror, convicted Murdaugh of killing his wife and son. Upon inquiry by the court, counsel requested that the jury be individually polled. The court polled them. They affirmed that their verdict was guilty. Less than a week later, Joe McCullough represented to media that juror 785 did not wish to speak publicly about the case and did not wish to be contacted. Rachel Sharp, quote, infamous egg juror in Murdaugh's trial asked to be left alone. The Independent, March 8th, 2023, footnote 7 is probably a link to that article. At some point unknown to the state, McCullough also assumed representation of juror 630 and so represents each of the jurors who have provided affidavits to Murdaugh. McCullough being the attorney that has a close relationship with Poot. Footnote 7, accessible at The Independent. So, the two jurors who provided affidavits are both represented by an attorney with ties to the defense, which is worth noting. State's motion to strike. In support of his motion, Murdaugh provides various affidavits which are deficient under the rules of evidence, notwithstanding any effort by the state to grapple with the affidavits in its arguments in sections 4 and 5. Below, the state must respectfully move to strike portions of the motion for new trial as follows. The state moves to strike as inadmissible hearsay the affidavits of the paralegal Holly Miller. Right, because the paralegal's like, I talked to this juror and they said this, but the juror wouldn't sign an affidavit. In support of his motion, Murdaugh provides two affidavits from counsel Harpootlian's paralegal, which largely purport to reflect statements made to or otherwise in her presence of two jurors. Hearsay is a statement. Elaine. Hearsay is a statement other than one made by the declarant while testifying at a trial or hearing offered in evidence to prove the truth of a matter asserted. 801C. An affidavit from Miller is not tantamount to an affidavit from the juror themselves and constitutes textbook hearsay. So the state is moving to strike consideration of those affidavits. The state moves to strike as inadmissible under Rule 606B. All such material as regards internal functions and deliberations of the jury. The jurors aren't allowed to talk about it, so the court can't consider it. In support of his motion, Murdaugh provides four affidavits which purport to reflect statements made by jurors which, in part, pertain only to juror mental processes and interactions with one another. As previously noted, jurors may neither testify nor may the court accept affidavits which pertain to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or another juror's mind or emotions, accepting claims of outside influence or extraneous outside information. Nick White, this document definitely tells a different story from Jim and Poot. Yep. That's why we like to cover both. Let's see. Remarks in the affidavits regarding jurors' thoughts about the evidence or one another are not properly admissible or relevant to the ultimate claim raised. Accordingly, the state moves to strike in part as improper juror testimony Motion for new trial, Exhibit A at lines 4 through 6, Exhibit B at lines 7, 8, and 10, Exhibit H at lines 14 through 15, J at lines 5 through 7, and any part of the motion that relies on those. The state moves to strike all materials regarding the Facebook post, book deal, post-trial media interactions as immaterial, impertinent, and scandalous. The greater part of Murdaugh's motion is dedicated to the outlandish theory that Courthouse Becky deliberately fabricated the existence of a Facebook post implicating juror 785 in order to get them removed from the jury, force an outcome, and thereby profit from fame and fortune. Fame is fake. Nobody's making a fortune on a self-published book or many books, by the way. Most people aren't making fortunes off of books. Some may, most won't. And the Facebook post is still sus. Two things can be true at once. To be clear, in an attached affidavit, Becky fires back. The revenge of Courthouse Becky. We're going to hear it later. To be clear, in an attached affidavit, Courthouse Becky affirms that she made no such deliberate fabrication, denies fabricating any Facebook post. Indeed, the machinations alleged do not even begin to make sense. Under Murdaugh's theory, Clerk Hill heard the court had received an email which implicated a specific juror, then in immediate response on the fly reported a fictitious Facebook post to implicate that same juror, then conspired with another staffer to quickly and by sheer coincidence be lucky enough to find an apologetic post by someone with the same name as the juror's spouse, which she then reported to the court in an effort to get an uncertain juror removed so as to ensure some outcome that would support a book deal she did not at the time have. I still don't think she has a book deal. I think it's self-published. Do we call self-published books a book deal? I made a deal with myself. I have a book deal, y'all. I just decided. I don't think that's how that works. Only Alec Murdaugh could conceive of such a confounded gambit as even remotely plausible. And he is projecting his own calculating, manipulative psyche onto a dedicated public servant in an effort to save himself. The prosecution has words in this. Words. Only Alec Murdaugh could conceive of such a confounded gambit as even remotely plausible, and he is projecting his own calculating, manipulative psyche onto a dedicated public servant. Strategically, Murdaugh's inclusion of the Facebook post narrative appears to be a desperate effort by Murdaugh to preemptively impeach Courthouse Becky, to bring into dispute irrelevant facts in order to support his petition for writ of prohibition pending in the Supreme Court of South Carolina. Well, not today, it's not. That's been resolved. CEG earlier in this stream. And to beef up what would otherwise be a thin, bland... What is bland in relation to beef? Counsel. What, you would like to be loquacious today. I get it. To beef up what would otherwise be a thin, blandly what? A thin, bland legal filing? Because blandly doesn't go there. Somebody fix this sentence for me. To beef up the thin, bland legal filing, not likely to draw attention to the various media efforts of his legal team. Yes, it needs to be outrageous. And then the media is like, oh, fuck. Whatever Murdaugh's motivation, the court expressly did not rely on the alleged Facebook post of removing juror 785. Therefore, whether or not Clerk Hill saw the alleged post is mistaken as to the alleged post or even fabricated it is of no consequence to the validity of Murdaugh's conviction or the actual claim raised by Murdaugh of improper external influence upon the jury. Accordingly, the state moves to strike entirely the motion for new trial exhibits E, F, G, and L, and strike in part exhibit H at lines 3 through 9, 13, 17 through 21, and the motion that relies on it. Oh my God, we're only on page 19. We're only on page 19. Argument 1, even assuming ad arguendo, I prefer just arguendo, but that's okay. Even assuming arguendo that all facts averred in Murdaugh's motion are true, the motion fails to make a prima facie showing that he is entitled to an evidentiary hearing or relief. Tell me why. Tell me why. Although Murdaugh's motion for new trial makes various allegations as part of its attempt to craft a breathtaking conspiracy narrative. I mean, what? It's breathtaking. A breathtaking conspiracy narrative. It ultimately boils down to a single constitutional allegation. The clerk told jurors not to believe defendant, thereby violating his right to an impartial jury. Yeah, that's the gravamen of the thing. It is. It is. Chat, you're correct. Ashley said, Emily, you can't make a book deal with yourself. You need someone to keep you accountable. If that someone is you, we're never going to see a book. Self-imposed deadlines don't work for ADHDers. They do not. But if we can call it a book deal when we self-publish, then can't I just say I have a book deal? Don't we all get to just like make it up? It's just a thing. It's fine. They've properly stated the gravamen of the case, which is the clerk is alleged to have told the jurors to disregard Murdaugh's testimony. Accordingly, even if the state assumes arguendo that all of the competent elements of the affidavits provided are earnestly given, the relevant analysis is as demonstrated by the questioning in State v. Green. 1, was the jury's verdict guilty? 2, was the juror's verdict based on the evidence presented? 3, was the juror's verdict influenced by the alleged outside communication? And 4, did the juror have any communications about the case outside of deliberations with the jury? All of the other details are irrelevant window dressing. Ew. Rude. So, footnotes 8 and 9 we need to get to. The defense alleged more than just this. The defense alleged that the clerk of court had one-on-one conversations, had more conversations with the jury, but the whole argument is that the clerk had conversations with the jurors and told them at some point not to believe the defendant's testimony. Footnote 9. It is difficult for the state to assume arguendo that they are all true, as they are not consistent with one another or with the trial record. So the state's like, we're trying to take the affidavits as earnestly given, but we're having a really hard time believing this bullshit. Only one juror who participated in deliberations, juror 630, ties to Clerk Hill any statements remotely consistent with Murdaugh's allegation of improper external influence. Not to be fooled, watch him closely, look at his actions, look at his movements. Even assuming for the sake of argument that this recollection is accurate, or that I'm just going to go with they, saying he or she is exhausting, that they are not misremembering arguments expressly made by the state, Juror 630 does not attribute their verdict to the statements of Clerk Hill, but rather states that they would have voted guilty despite some questions because they felt pressured by other jurors, which is not a motion for new trial. That a juror felt pressured by other jurors is not a valid basis to impeach a verdict. That's how that works. Due process not implicated where other jurors verbally abused a holdout juror for at least 4 hours, which shouldn't happen. You should not be verbally abusing each other. At that point, look, if you're ever a juror and you feel verbally abused by the other jurors, you tell the court, I cannot come to a verdict because I am being verbally abused by other jurors for 4 hours. But coercion or compromise is part of the jury system. You chat with each other. You try to change each other's mind. You negotiate. What about this evidence? What about that? How about this? That is how the jury process works. Verbal abuse should not be how it works. Nor does juror 630's complaint about feeling pressured by other jurors constitute evidence that he or she, that they, or any other juror voted to convict because they were influenced by comments they allegedly heard from Clerk Hill. Murdaugh offers an affidavit which purports to represent statements made by juror 326, although the affidavit is that of counsel Harpootlian's paralegal. Even if the state accepts arguendo that Miller's affidavit is the equivalent of an affidavit from the juror themselves, it is unavailing to Murdaugh. The juror contradicts juror 630 and recalls no such comments by the clerk regarding Murdaugh's credibility. What juror 326 did recall was a warning that the jurors would witness disturbing images, which is a neutral trigger warning and not one which puts a thumb on the scales of justice. To be sure, the jurors did review disturbing images. No affidavit attached to Murdaugh's motion from or about a deliberating juror shows any effect on the verdict, including juror 630. Nothing else offered by Murdaugh helps meet his burden of making a prima facie showing. Neither juror 785 nor juror 741 participated in deliberations and thus cannot aver that the deliberations were influenced. That's fair. If they are not deliberating jurors, they can't say that anything Courthouse Becky said persuaded or influenced their jury because they weren't there to deliberate. Absent any representation that a deliberative juror's decision that Murdaugh was guilty was actually influenced by improper communications alleged, Murdaugh has failed to make a prima facie showing necessary to justify so much as an evidentiary hearing, let alone a new trial. Accordingly, the motion should be denied. So their argument is, look, you need to show that whatever is alleged to have happened influenced the outcome of the jury. And Murdaugh has not shown that. Argument 2. Should the court deem an evidentiary hearing necessary, the state expects the material allegations will be shown to be not credible. Tell me more. In the event the court concludes Murdaugh made a showing sufficient to necessitate an evidentiary hearing on the matter, the state accepts that sworn testimony to the court will prove the allegations to be unfounded and not credible. Since Murdaugh's filing with the Court of Appeals, agents from SLED have successfully interviewed most of the jurors and the final alternative juror. One juror declined to discuss the case or deliberations, juror 578, and 2 jurors are represented by attorney Joe McCullough, 630 and 785, who at the time of this writing has yet to consent to an unconditional interview with his clients. They talked to the defense. Just saying. Clerk Hill denies commenting to the jury regarding Murdaugh's defense or testimony. Upon information and belief, SLED's investigation into the allegations of jury tampering produced the following answers from jurors who deliberated. Juror. Okay, so we've got a chart. Here remarks on evidence by the clerk. See one-on-one chats with the clerk and the jurors. Other concerns. Juror 193. Here remarks on evidence by the clerk. No, maybe generally pay attention. Still not proper, but not going to rise to the level of a new trial. The clerk should ask them what they want for lunch, and that's about it, and not have any other commentary. However, I also understand that keeping that kind of distance may be uncomfortable regionally. It's like, hey, we got you guys. You can't be friendly, chitty chat with the jury. See one-on-one conversations? No. Other concerns? If anything, people were overly cautious. Juror 254. Here remarks on evidence by the clerk. Watch Murdaugh's body language. That confirms what other jurors said in the defense motion. See one-on-one chats? No. Other concerns? No. Juror 326. Here remarks by the clerk. No. Graphic material warning. Still not appropriate. And that should come from the court. If anyone's going to say you're going to see disturbing images, that comes from the court. See one-on-one chats by the clerk. Yes, saw a chat regarding financial or child support. What are you doing? No. That's not no. It's probably not a motion for new trial, but it's not appropriate. Juror 530, negative ghostwriter. The pattern is full. Juror 544, no. Generally pay attention, look at body language, be observant. That's 2 now. That's 2 that say that the clerk said, look at the body language. And 3 that have said, or 2 that have also said, pay attention. Still shouldn't be happening. Is that enough to prejudice a jury? Probably not. Other concerns. Juror 630 is a tenant of juror 785 who was upset. What now? What now? Juror 630, the one represented by the same attorney as juror 785, is also a tenant of juror 785. Warned by counsel Harpootlian of a subpoena if they did not talk. Are you threatening me with a subpoena, sir? Well, if you don't want to talk to us, we'll subpoena you. That's not how that works. Huh. Anyone else think that's interesting? That the tenant, another tenant, so juror 785 is accused of talking to other tenants when delivering a refrigerator, and now is also on the jury with another tenant, and that other tenant is represented by the same lawyer that is close with the defense. Interesting. Isn't it? Isn't it? Just saying. And warned by Harpootlian of a subpoena if they did not talk. Do you think Harpootlian said that in a kind way? Because we saw Harpootlian in court. Well, if you're not going to talk to me, this is my speculation. Well, if you're not going to talk to us, you're going to get a subpoena. Rah, 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 rah. Yeah, I don't think that was friendly. Juror 572 is like, I didn't see anything. Juror 578 is like, leave me the fuck out of this. All. Juror 589, nope. Spouse warned by Harpootlian of a subpoena if they did not talk. The chat, I was trying to grab this one. Airy Deary said, landlord, egg juror, monkey juror. Yeah, same. The landlord juror is also the egg juror that got dismissed. But also, Emily and I said, what now at the exact same time? Yep. I wonder if jurors were picked because they live in the same apartment complex. They subpoenaed over 1,000, or they summoned over 1,000 jurors in a pretty small town. So I'm not surprised that jurors live next to each other. So another juror, spouse warned by Harpootlian of a subpoena if they did not talk. Juror 630, no interview at the time of the writing. Juror 728, no, generally pay attention, heard no body language comments. Yes, had a chat regarding financial child support, saw the clerk chat with others. But wasn't that also with juror 785 that the juror was worried about the ex-husband? Also, no, the clerk should have shut that down. Other concerns, denied statements regarding them in affidavit of juror 785, uncomfortable when Harpootlian waved the gun around. Finally, someone's on our page. Lawnards, us and juror 729 are all on the same page. Uncomfortable when Harpootlian waved the gun around. Same. Juror 826 was like, negative ghostwriter. Juror 864, it was Creighton Waters in court argument who told the jury to watch body language. And that is what the prosecution's putting forth in this motion. The prosecution is saying, look, we told them to look at body language. That didn't come from the court clerk. But other jurors remember Becky Hill saying, pay attention, look at body language, be observant. But did those comments if those comments were made, if those comments weren't comments from the prosecution, if those comments came from the court clerk, did those comments cause these jurors to come to a specific verdict? Exhibit B, redacted written statements of jurors. Perhaps most importantly, none of the jurors who willingly interviewed with SLED reported feeling any pressure or influence to reach their verdict. So there may be improper communications that did not influence the jury. You have to get both prongs, right? I thought what the juror did in Maxwell was wildly inappropriate. And even there, the court's like, it doesn't reach the level of a new trial. In addition to the jurors, SLED interviewed court staff. Jury coordinator Willard Polk Jr. reported that he was the interface between jurors and the court and did not hear Clerk Hill or anyone else attempt to influence the jurors. No court staff witnessed any external influence on the jury either. Exhibit C, redacted statements of court staff. Altogether, the allegations raised in the affidavits provided by Murdaugh can be explained as a combination of simple mistakes and, unfortunately, a non-credible affiant. They are calling out Egg Lady. As noted previously, a brief review of the record reflects the verbiage that Juror 630 recalled is, as Juror 864 noted, more properly attributable to the arguments of the state. The state argued to the jury not to be fooled by Murdaugh. The state advised the jury to watch Murdaugh closely in the context of his video's recorded statements. The state emphasized importance of body language. Juror 785, purportedly the landlord of Juror 630. Juror 785, purportedly the landlord of Juror 630, was removed from the jury after the court determined they improperly conversed about the case with other tenants during the trial. Juror 785 only recalled the, quote, fooled by language, which was actually articulated by the state in its closing argument the day before the juror was dismissed. But most importantly, the clerk specifically asked the juror during the in-camera hearing if the clerk had discussed the case with her or any other jurors to her knowledge, and she replied, not that I'm aware of. Cameron Does Stuff said, read the affidavits. Oh, we're going through the whole thing. We're in it for the long haul. We're just in. We're in. As just said, if Becky said or did those things, it's still improper. I don't think Becky should be talking to the jury at all, but it might not rise to the level of influencing the jury. So it might not be tampering. This might be something that the court has to deal with. Aren't the jurors supposed to not have to talk to attorneys? Yes. You don't have to talk to them. But if Poot's like, well, we're going to slap a subpoena on you, it could intimidate people. We live here now for sure. Jen said, so what changed, egg juror? So the two jurors live together. It seems that one juror is the tenant of another juror who is the landlord in an apartment building situation. All right. The prosecution goes on to say it strains credulity to believe that Juror 785 would not be aware of the clerk's supposed statements when specifically asked by the court at the time proximate to when they were allegedly made, but would suddenly recall them many months later after learning the clerk published a book. The remainder of Juror 785's affidavit reports incredible one-to-one conversations with Clerk Hill, which, aside from the juror's inconsistent but more credible denial to the court, pertain only to the wholly irrelevant Facebook post. Finally, contrary to the juror's affidavit in support of the motion for new trial, the tenants of Juror 785 affirmed that the statements they made in their affidavits at trial and in camera testimony. So they're saying that juror's statements have changed, and that juror's statements already go against what the other tenants say. Alternate juror 741 would not sign an affidavit as requested by Murdaugh's counsel and was evidently reluctant to do so. See, Alec Murdaugh's defense team seeks new trial amid jury tampering reports. The Untold Story with Martha McCullum, 2023. Juror 741 told SLED investigators that the clerk told the jurors that, quote, the defense is about to do their side and don't let them confuse or convince you. They may say things to confuse you. However, neither juror 630 nor 785 clearly corroborate juror 741's recollection, and no other juror even comes close to doing so. Juror 741 told SLED that she was aware that the clerk wrote critically of her attentiveness during trial, and additionally noted that the clerk told her after trial that no members of the media wished to speak to her. Why does that read like, you mad, bro? You mad? You mad? That's what they're trying to imply, I think, that juror 741 is mad about the way Clerk Hill spoke about her. I don't think Courthouse Becky should be writing a book talking about the jurors at all. You're the clerk of court. You're the clerk of court. It is not your job to shit talk jurors in a book and say they weren't paying enough attention. It is improper. And juror 741 is like, oh yeah? Don't do that. Also, when the prosecution, look, I get that the prosecution's protecting their case, but they are protecting Courthouse Becky a bit too much for me. Because here's the thing. If the prosecution is saying that questioning the jurors is going to make people reluctant to do jury duty, how is writing a book critical of those jurors going to do anything other than make people reluctant to go do jury duty? Because they're sitting there being like, oh, you're judging me? I have to be here for jury duty and you're judging me? You're judging how I'm doing it? Great. Don't write the book. As Bruce Rivers says, stop self-stitching. Courthouse Becky I can't talk. Courthouse Becky is self-snitching on being kind of a judgy mean girl. And I don't like it. Leave the jurors alone. Don't write about them in a book. Also, it's just tell that to Keefe D as well. Keefe D wrote a book that might very well land him in prison for a very long time. And Clerk Hill was like, the media doesn't want to talk to you. Yeah. The media would have talked to any of these jurors. Come on now. The media would have talked to any juror that was willing to talk. So who is Courthouse Becky to gatekeep who the media talks to or not? It's a weird fucking flex. And I get that the prosecution's like, oh, well, Courthouse Becky was mean to this juror in their book, so this juror is going to say some shit. Courthouse Becky shouldn't have been mean to any of the jurors in any book. I still don't like it. It doesn't mean they get a motion for new trial. I don't like it. The greater weight of anticipated juror and court staff testimony is that Clerk Hill made no materially improper comments. Materially improper comments. Any comments are improper. Don't talk to the jury. That's your job. But they made it very clear. Materially improper comments. The state denies Murdaugh is entitled to relief and anticipates that any evidentiary hearing will only reaffirm the validity of his conviction. Maybe. Furthermore, even if Courthouse Becky made improper comments to the jury. The state has found no juror who will aver that anything Courthouse Becky said or did influenced their verdict. And that is the point. I don't like any of it. But if it did not alter their decision, then you don't get a new trial. The court clearly instructed jurors to consider only the competent evidence presented to them and apply the law. Each juror reaffirmed their verdict. Conclusion: the state respectfully requests the court deny the motion for a hearing, deny the motion for new trial. Don't do the things. Let's see. Barring that, convene an evidentiary hearing consistent with that conducted in State v. Green, and upon hearing the testimony of the jurors and witnesses presented, find Murdaugh's allegation to not be credible and deny the motion. I want to see a hearing. Let's see what Courthouse Becky has to say. Shall we? Signed affidavit. Personally appeared before me the undersigned notary public, Mary Rebecca Hill, over the age of 18. Affidavit is submitted at the request of the Attorney General of South Carolina to address specific allegations contained in affidavits attached as exhibits to Mr. Murdaugh's motion for new trial filed October 27th. There are numerous misrepresentations and false statements contained within the motion for new trial to which I was not requested to specifically address. Stop trying to overwrite things and just speak plainly. As such, this affidavit is not intended to address every allegation contained within the motion. After being elected in 2020, I have served as clerk of court in Colton County. I was the elected clerk of court during the case of State v. Murdaugh. I have reviewed Murdaugh's motion for new trial. As to the allegations contained within from Juror 630, I did not tell the jury to, quote, not be fooled by evidence presented by Murdaugh's attorneys. I did not instruct the jury to watch him closely. I did not instruct the jury to look at his actions. I did not instruct the jury to look at his movements. I did not say to the jury, this shouldn't take us long. When juror number 826 asked to speak with me, the conversations took place in the jury room hall within earshot of bailiff Bill Polk. The conversations did not involve the evidence, witnesses, or substance of the trial. It shouldn't have happened either way. Don't talk to the jurors. As to the allegations within the affidavit, it's not enough to overturn it. It's just not proper. As to the allegations within the affidavit of Holly Miller addressing an alleged conversation with juror 741, I did not have private conversations with juror 826 in a bathroom. I did not have conversations with juror 826 on a plane. I did not have conversations with juror 826 in the rain. I do not like conversations with juror number 826, Sam I am. I do not like them. Or green eggs and ham. Chad is asking for code green. Chat. Look, I'm a real streamer now. Chat. Code green. Code green. Do we need code green? Okay. Granted, chat. Granted. Let's go to code green. This one is not as flashy as code red, and it stops when the music stops. Code green. All right, chat. We are at code green. Chat. Things I hate when people stream. That. I hate it when people do that. During the trial, I did not tell members of the jury that the media would want to interview them at the end of trial. You didn't? Really? Sure. I did not tell jurors, y'all are going to hear things that will throw you all off. Don't let this distract or mislead you. No. She said, y'all are going to hear things that will throw y'all off. So this is not. As to the allegations within the affidavit of Juror 785, I did not tell the jurors not to be quote unquote fooled by the evidence presented by Murdaugh. I did not ask the juror whether the juror was inclined to vote guilty or not guilty. I did not tell the juror that SLED and the Colton County Sheriff's Office personnel went to her ex-husband's house. I did not tell the juror that I would, quote, reinstate a restraining order against her ex-husband. I did not state to the juror that the Murdaughs probably got to him. I did not ask the juror about their opinions regarding Murdaugh's guilt. I did not ask the juror, well, what makes you think he's guilty? I did not discuss the evidence with the juror. I did not tell the juror that everything Murdaugh said had been lies. I did not tell the juror, forget about the guns, they will never be seen again. I mean, these are wild fabrications. Like, where is the... This is like, it's just so wild. This juror's like, she said all of this shit. And she's like, I said none of this shit. There's got to be something in the middle here. It's wild. It's so wild to me. I did not ask the juror their views of the rest of the jury. I did not tell the juror the foreperson would just go in and ask for a raise of hands and this would be over and done with. I did not tell the juror everyone needs to be on the same page. I did not fabricate or create a Facebook post. As to the allegations about juror 326, I did not tell jurors they were prohibited from taking smoke breaks during deliberations. My favorite part.
Further affiant saith not.
It's my favorite part of these affidavits in South Carolina. It's not everything I said is true. It's further affiant saith not. Exhibit B, written statements of jurors. Oh, yes, let's. Juror 193, voluntary statement. Redacted, agent redacted. I was not coerced to give my verdict. I came to the decision of my own free will. No, I did not feel anything was said to influence my decision making. I did not witness any private conversations pertaining to the trial. Were there any at all? And was not approached by anyone. I did not witness any jurors speaking privately about the trial. I did not feel pressured to come to a quick verdict or that I was required to reach a verdict in a certain time frame. I have not spoken to the defense team. To my knowledge, no juror attempted to begin deliberations early. Juror statement, juror 254. This was my first time as a juror, and I found that this experience was very rewarding as a civic duty. Well, that's so nice, juror. During the time we as a jury were treated with respect and received anything that we requested. The only time that I had an interaction with anyone was through the bailiff. That's what should happen. Other than one time when we as a jury were waiting to go into the courtroom and a comment was made to watch his body language. At that time, I didn't take it any way other than to watch his body language. That comment didn't persuade me of the decision that I ultimately made during deliberations. I don't know about y'all, but I'm beginning to feel like the watch his body language statement happened. I don't know if it's prejudicial, but I'm interested. But also, I need more context. Was this being said to a juror? Or if they were in the hallway, was this being said between other parties? Were other parties talking in the hallway within the earshot of the jury, which also shouldn't happen? But who said watch his body language, and were they talking to jurors, or were they talking in the vicinity of jurors? There's more questions there. How many people really know about body language? It was quite a lot of conversation. Who said watch his body language? It does not state. It does not state. It says we as a jury was waiting to go into the courtroom, and a comment was made to, quote, watch his body language. At that time, I didn't take it any way other than to watch his body language. That comment didn't persuade me of the decision. But they were waiting in the hallway. So was the court clerk talking to the jurors? Were court staff talking to each other? Because court staff talks, but they shouldn't be talking in the presence of the juror. But I'm beginning to feel like that statement happened, but that it's not as nefarious as it's being pointed out. Nikki said, did perhaps a juror make that comment? It's possible. I believe that my interaction with Ms. Hill, the court clerk, was limited to information from the judge or about important events such as graphic material or how long of a break we would get. Again, that should all go through the bailiff, but if this court does it through the clerk, sometimes the clerk will say, you guys have 15 minutes. Do you need anything? I do not believe she acted outside her role as a court clerk and acted in a very professional manner. Juror 530. I did not at any point feel pressure to make a decision throughout the trial, nor did anyone attempt to sway my decision by any means of communication. At no point in time throughout the trial did anyone attempt to have a one-on-one conversation with me for any purpose regarding the trial. To the best of my knowledge, there was no court official or employee that questioned myself or other jurors regarding the trial or its outcome. To this date, I have not been contacted by the defense regarding the new allegations or other topics. Throughout the trial, I did not observe anything that I perceived to be unethical by any court employee. I am dyslexic. These are difficult for me to read. Juror 544. This will be easier. While on the jury, Ms. Hill never made me feel as though she was trying to sway me either way, innocent or guilty. Ms. Hill spoke with us as a group in regards to what type of things we would like for snacks, breakfast, and lunch. I'm so hungry. Ms. Hill mentioned if we were sequestered that we would be staying at a hotel and we would be given time to gather our things to stay at the hotel. That's different than what was said in the defense motion. She also stated that an agent or officer would be with us the entire time. I felt she stated this to us as trying to keep us informed of what may or could. Darn it! It doesn't say might could. It doesn't say might could. What may or could happen. I was never made to feel pressured to say or do anything by anyone, court employees or co-jurors. I never witnessed any jurors going into a room alone with Ms. Hill. Juror number 572. No, I was not coerced to give any answers. My decision was my own. No court employee influenced my decision. I did not have any private conversation other than myself and talking to Miss Becky Hill about me not using the stairs because of my knee injury. That is a proper type of a conversation. Hey, Miss Becky, I can't use the stairs to get up and down. Is there an elevator? That's proper court communication. What a great example. I did not witness any private conversations amongst other jurors. I did not hear or witness anyone or any court officials stating to us, the jurors, that we should not listen to the witnesses or shouldn't take long or it shouldn't take long. No one made me feel that I had to arrive at a quick verdict. And if I didn't, I or the other jurors would not be able to leave. No one from the defense team ever reached out to me pertaining to the Murdaugh trial. Another juror that was ejected from the trial stated one morning on the van that her husband told her we were going to Moselle and we told her no discussions. Oh, the egg juror. The egg juror said, my husband told me we were going to Moselle. The egg juror had a lot to chat about. Oh, God. Okay. I I'm gonna try on this one, but your guess is as good as mine. Egg juror was properly yeeted. Yep. What is this? I don't know. Yikes on bikes. Yep. You guys are like, skip it. This was scanned by a potato. I'm gonna try it. Okay, give me a second. This is talking about Mr. Beast. I don't know what it's doing here. I'm kidding. It says member. I was a member of the jury. When we would go back to the jury room, people would go to the rooms where they wanted to sit at. Most of them stayed in the same room at the beginning. Miss Hill would come in person to see if we needed anything. Question, did Miss Hill ask questions about your opinion? Answered, no, she did not. Question, did Miss Hill pressure you to speak to? Redacted. I felt no pressure to speak. 729. Also scanned on a potato. But the handwriting is very clear. Okay. Celio in the chat said, did they use papyrus paper from the 6th century? The scan is giving me no signal on my TV. Is that a hidden picture? Yes. You guys, I am looking at this on a very large screen in front of me. But it is. Oh. Ah. During a 6-week trial, I found that with 2 different rooms, there would be a lot of gossip between strangers. Each room was filled with men and women. The room was in a quiet room, while the other room was a louder and filled with conversations of work and private life. So there were 2 juror rooms. They were split up. One was a loud room, one was a quiet room. I mean, some people need a moment. I like they have a quiet room. I spoke with Becky Hill on a couple occasions about my financial burden and that I needed to speak with the judge. Like, Your Honor, I can't do this trial for 6 weeks and get paid $15 a day. Smoke breaks once a day, sometimes more. She did come to speak to others, but I didn't hear the conversations. During the trial, I had a very uncomfortable feeling as the defense attorney would wave the gun around as if he has never held one before. That's what we said. During our smoke breaks, we would talk about lunch or what we were missing at work. There was always something to talk about or someone to talk to. After 6 weeks, it came time for deliberation. Everyone took an anonymous vote followed by open discussions and questions. It was fast and smooth, but I felt no pressure. I was set in my decision. After everyone discussed our thoughts, we voted again. Every vote came back guilty. We checked multiple times to see if we were all comfortable with the decision. If we needed to wait, we would have. On the day of sentencing, we were approached by Dateline and Miss Hill, who asked if we wanted to do an interview. We told her no. She seemed disappointed, but let it go. You don't want to be on Dateline? I'll do it. I'll talk. I have thoughts. Question, did you ever hear anyone tell the jury, quote, not to be misled or fooled by evidence presented in Mr. Murdaugh's defense? Answer, I did not hear anyone say not to be misled or fooled by the evidence. Question, did Ms. Hill ever ask you your opinion in regard to the trial? No, I did not have conversations with Ms. Hill like that during the trial. Did you have conversations like that with Ms. Hill after the trial? I've got questions. Have y'all been talking about it since? I want to know. That's just me being curious. Question, did you ever feel pressured to make decisions prior to deliberations? At no point during the trial did I feel pressured to make my decision. Oh, thank God. Juror 826. Question, did you feel pressured at any point during the trial to make a decision? Answer, no. Question, did any court official or court employee pressure you or any other juror one way or the other as it pertains to guilt or innocence? No. That's a compound question. Did any court official or court employee have one-on-one conversations with you or any other juror? No. Did anyone attempt to contact you after the trial regarding the trial? No, except by the media. Did you see anything during the trial that you perceived to be inappropriate or unethical? No, not that I recall. Question, did any court official or court employee question you or any juror prior to deliberation about decisions of the jurors regarding guilt or innocence of the defendants? No, not that I am aware of. Oh, that hurt my head. Juror 864. No one pressured me to make my decisions of guilty. No one influenced me to make any decision or say anything. I can't read that middle part. Something to a guilty verdict. I did not. Something of witnesses, anyone having a private conversation about the case. Or I did not witness anyone having a private conversation about the case. I cannot read the rest of that. If I had to assign a profession to this person, I would assign doctor. Because that's how doctors write. I can't. Exhibit C, written statements of court staff. I did not have any personal knowledge of any contact between Rebecca Hill and the jury during the Murdaugh trial. My job as deputy clerk was mainly to gather lunch orders and deliver lunch to jury and others. I personally had no contact with the jurors other than delivering their lunch and making sure they had what they ordered. I spent the majority of my time in my office in family court and had no contact with the trial or any matters pertaining to the trial. I did not observe Ms. Hill or any other court employees speak with any jurors during the course of the Murdaugh's trial, except the bailiff that was assigned to them. I was asked to look through social media for a post regarding a juror speaking out. No, none was found. An apology post that may or may not have been associated was located and given to Ms. Hill. During the Murdaugh trial, I served as the jury coordinator. My responsibilities constituted mainly as the primary interface between the jurors and court officials, like any medical or personal issue, etc. In my jury coordinator position, I did not personally hear anyone interface. This person is a sheriff. Yep. Anyone interface with and try to influence the jurors. I did not hear the clerk of court, Rebecca Hill, try to influence the jurors. My jury responsibilities kept me busy, and I didn't hear anyone try to influence them. Generally, they know no one's going into the room. This trial was very important for Alex Murdaugh and the Colton County Courthouse, so I tried to keep everything professional and problem-free. The jurors became like family after being together for 6 weeks. I have not seen or talked to any of the jurors since the trial. Voluntary statement supplemental. Question, did you ever hear any court official, clerk of court tell any jury not to be misled or fooled? I did not have knowledge of anyone asking the above question. Did you ever get told by jury members or hear anyone tell the jury members from the outset that it shouldn't take them long? I did not hear anyone ask a juror the above question. Did you ever observe Ms. Hill speaking with the jurors privately? I did not, except for 2 issues. One was a personal financial issue, and one was a child support issue with a male juror. I was present with her for both of these issues. These occasions were at the very beginning of the trial week. Were jurors allowed smoke breaks? I did not take the jurors out. I did not take the jurors on smoke breaks. Once deliberations started, this has always been the policy since I have been working with the jurors. So It is not the policy of the court that they take smoke breaks while deliberating. My job during the Murdaugh trial was to control the gallery and seating them and lawyers and press in proper places during trial. I in no circumstance seen anything inappropriate by Becky Hill. All I witnessed was the clerk of court performing her normal duties as a clerk. That is it. The prosecution has put forward very different statements than the defense. Very different statement than the defense. Here's where I'm at the end of all of this. Was Courthouse Becky's book a terrible idea? Fuck yes, it was. A terrible idea. Do I think there were some conversations that either the jury heard or that were had? Yes. Do I think those conversations were improper based on this? No. Because I can see one juror looking at a conversation between Becky and another juror being like, oh, they're having a private conversation. But that juror is like, no, you don't understand. I need to talk to the judge. I'm financially stressed about this trial. Could I see that miscommunication happening? Absolutely. This is why you do not talk to jurors one-on-one, because somebody else sees it and goes, that's inappropriate. Why are you talking to that juror? The perception is a problem. So there's these little things that could have been misconstrued. I think it is very interesting that the two jurors who spoke with the defense are both represented by the same attorney that has ties to the defense and both live in the same building. It's an odd coincidence to me. It's like noted. Like I've got like that. I'm not going to forget. That is tick, tick, noted. Don't like it. What else? All of the jurors said they weren't influenced. I don't know if the defense is going to make their prima facie showing that there were conversations and that those conversations influenced the outcome here. Do I think there could have been conversations? Yeah. Do I think those conversations impacted this jury? No. At this point. Do I think this was advocated differently by the defense than the prosecution? Absolutely. This is what advocacy is. Do I think it would be better if the clerk didn't have any conversations with the jurors? Yes. Sometimes that's just not practical when you're asking them for lunch, when they're saying that they've got things they need to talk to the court about, when they're asking the court clerk about, what was the other one? Child support. I can understand how these conversations come up. I can also understand how somebody else sees it and is like, they're having a one-on-one conversation. I want to know the juror who was like, oh, I didn't go to the bathroom. Or I didn't go and talk to the bathroom. That's an interesting thing. So that is kind of my quick summary. Advocacy is interesting, isn't it? I think we will see. Could this backfire on the defense? Yeah, it can, because it's going to change people's perception. Look, if you don't trust the defense, if you're coming into this not trusting Poot and company, and you're looking at this, you are going to look at this and be like, oh, they blew all of this way out of proportion. Do I still have some questions here? Absolutely. Absolutely, I do. Do I know if they've met the threshold to get a hearing based on what we've now seen? I don't know. Do I think the cleanest way to handle this is to have a hearing? Yes. Do I think judges are reluctant to put jurors on the stand and question them? Yes. What comes next? The defense will have a reply. And then we'll see if the court rules on a hearing. There is a hearing tomorrow. Will it be a hearing on this? No. but it's going to talk about the next part, and we're going to get to that now. But I saw another question. Did the judge step down? Peter has a thumbnail about it. I covered it at the beginning of the stream. Judge Newman voluntarily recused himself on the motion for new trial, this motion about Courthouse Becky. So that. Will I probably also have a thumbnail about it in the future? Yeah, the news came out as I was streaming, and I will put up a quick bit about it. Miguelina and I will probably cut down my coverage of that and put it up on quick bits for you guys. Will the hearing regarding Becky be televised? It should be. It should be. And it should be a hearing about, it's the motion for new trial, but that's not the hearing for tomorrow. We need to talk about the hearing for tomorrow right now. So we're going to go back to regular recording colors for a minute. And we are going to talk about the motion to delay or change venue right now. Miguelina, can we update our pinned post that we're moving on to Murdaugh's motion for new venue? Thank you. All right. Let's see. This is the most recent motion from Murdaugh. This was filed on the 13th of November. What is today? The 16th. So this motion was just filed This motion was just filed a few days ago. We have one more motion to get through today, and then questions. I promise. And then I might look at how wrong the headlines are about Judge Newman. Because it would be funny. All right. Let's see. So far, not too bad, actually. Yeah, so far, not too bad. Let's cover this motion, shall we? Motion to transfer venue. Ba-bump. I need a ba-bump noise at some point. Motion to transfer. Well, we swooped. I guess swooping is enough. All right. Motion to transfer venue. This is a defense motion. Defendant Murdaugh, through counsel, moves the court for an order transferring venue of the trial of this case. This case being the financial crimes case with regard to Gloria Satterfield. That's the case we're talking about. Transferring the venue of the case or a continuance of the trial schedule. The trial is scheduled for the end of November. Defendant has received unprecedented media coverage since the murder of his wife and son in 2021. Look, Poot, y'all went to like Crime Con and joked about the fact that you felt like celebrities. Stop. You're playing into this as much as everybody else is. This case is very interesting. And it's not unprecedented. CEG, every other high-profile case ever. Defendant's trial on murder charges was broadcast live to multiple media outlets and seen by millions. We're multiple media outlets. The trial concluded in March 2023. Since then, we actually had the highest viewed live streams of the trial day in and day out. We were at the top of the streams for this trial. It's where everybody wanted to watch Murdaugh. Since then, there have been 2 docuseries devoted to the trial, and 2 movies about the defendant have been released. I haven't watched all of them. It is what it is. As a result of this publicity, the jury panel has been provided with a questionnaire to complete, which includes questions about their knowledge of the defendant or this case. Not surprisingly, my voice. All right, I'm back. I was looking for my throat spray. My voice is still thrashed from Vegas. All right. Not surprising, there have been 167 questionnaires returned thus far, and at least 147 panel members admit having prior knowledge about the defendant. Well, a jury only needs 12. You got at least 20. So, Northwest said not televised if a jury is testifying. They can do audio. They absolutely can. At least 147 panel members admitted having prior knowledge about the defendant and his criminal charges. There's a spectrum of this thing though. Is it like, yeah, I've heard of Alec Murdaugh, or is it like, bro's guilty? Like there's a lot of difference in there. The code, stick to the code, authorizes circuit courts to order a change of venue to another county within the same circuit if pretrial publicity would deprive a defendant of a fair and impartial jury. Poot, you have said multiple times that this is an unprecedented international case. Where are you going to go? Go grab jurors from further away. Just grab more. The code authorizes the court to impanel a jury from any county in the state and transport the jury to Beaufort. Yeah. Embiggen the net to bring the jurors in. When a change of venue motion is predicated on pretrial publicity, the relevant inquiry is whether potential jurors have such fixed opinions that they could not judge impartially the guilt of the defendant. I mean, he pled guilty to the federal parts of these crimes, and he admitted it at the murder trial. So, it might be a little hard for jurors. I get it. However, a simple statement from a juror stating that he can set aside what he has previously heard to be fair and impartial should not be blindly accepted. The United States Supreme Court vacated a death penalty conviction where 8 of the 12 jurors thought petitioner was guilty before being selected, but claimed that they could be fair. Look, for me, there is a difference between I think someone's guilty, but I can set it aside, and I've heard of this person, but I can set that aside. If you've made up your mind, you should not be on the jury. The court explained no doubt each juror was sincere when he said he would be fair and impartial to petitioner, but psychological impact requiring such a declaration before one's fellows is often its father. Luke. Indeed, the 14th Amendment's Due Process Clause safeguards a defendant's Sixth Amendment right to be tried by a panel of impartial, indifferent jurors. The Court of Appeals for the 11th Circuit, has acknowledged that the trial court may be unable to seat an impartial juror because of prejudicial pretrial publicity or an inflamed community atmosphere. And in such a case, due process requires the trial court to grant defendant's motion for change of venue or a continuance. Further, prejudice is presumed from pretrial publicity when pretrial publicity is sufficiently prejudicial and inflammatory. Here, the exhaustive media coverage about the defendant has permeated Beaufort County, as reflected by the jurors' responses received thus far. Remember, the murder trial was in Colton. They don't seem that far apart, but it was a different county. Also, it is very unlikely that prospective jurors from any county in the circuit could have been less exposed to Murdaugh media coverage than Beaufort County jurors. Transferring venue to another county in the circuit would not be an option. There are perhaps counties located in upstate whose citizens have not followed the coverage of the defendant as closely as citizens in the Low Country. However, this is very doubtful in the present media climate. The better course. Oh, Poot, do tell me what the better course of action is. The better course of action is simply to continue the case and the other financial fraud cases until at least 1 year after the conclusion of the murder trial. What is the rush to dispose of this case before the end of 2023? Well, I'm just answering for me here, but the victims do deserve speedy justice. A speedy trial right does go both ways, not just to the defendant. The prosecution has the right to keep trials going. Witnesses' memories fade. You will argue, Poot, that memory has faded. People get incarcerated. People pass away. Shit happens. Why the rush? Because the witnesses are available now. Heather said Ori could plead guilty because he kind of already did. I don't think the state will let him plead guilty unless he pleads to everything. And I don't think he wants to plead to all 13 counts. So I think there is a push-pull there with him pleading guilty. I think the state doesn't want to give him a plea deal. So he would have to plead open. The defendant has entered a plea in federal court to the same conduct for which he will be tried in this case. The victims will have their day in court at the defendant's federal sentencing. Certainly, there are older criminal cases pending in the court with victims who are waiting for their rights to be vindicated. There is no good reason to try this case or any other pending case against defendant ahead of older pending criminal cases. Okay, Poot, not your job, first of all. Second of all, they get to decide when to do it. Third of all, he can plea open to the court. Go plea open to the court then. That's it. Plea open to the court. He pled to the financials in federal court. He did not plead to the state charges. Let's see what else they have to say. Exhibit A, sample of potential juror responses. Great. We don't know what the questions are, though. So all we get is the answers. I know too much history of the man on trial due to crime shows. Oh, wait, they've named some of the crime shows. Social media, the behavior panel, FYI, they analyzed body language. Buster was on one. Hello, behavior panel. Netflix specials on the Murdaugh family. Yes, I have followed Murdaugh family stories and Netflix series. As I mentioned before, I have heard too much about this family and cannot be impartial. Yes, from the documentaries. I have read and reviewed all information available to the public. Some people are like, I know everything. Everything that has been shown on television and in the media, also the murder trial and conviction. Watched the HBO series, closely followed the trial. My spouse was very interested and we all discussed and followed the case extensively. I believe he's guilty of killing his wife and son, if that counts. Watch the news, listen to a podcast or two, and watch the Netflix special and other streaming doc that I can't remember the name of. I've watched all the documentaries about this case on Netflix. I've followed the majority of his criminal case online. No, my mind is made up on this case. My mind is made up on this case. My mind is made up on this case. Guilty! Exclamation point. What that family did is disgraceful. I wish I had a white privilege card. That's it. Okay. I have seen all the news about this. If you want an unbiased, I am not your juror. My mind is made up on this case. This jury is not holding back. No, I have been exposed to a lot of information about this defendant. Netflix docs, news, radio. I reside in Beaufort County. Any individual that has resided here for the past 9 years has read local media, even national media, and followed all or some of this case. Yes, news, media, and shows about the case. I have watched and read a lot, if not all, the shows and articles about Alec Murdaugh. Hi, potential jurors. Apparently, you're all here hanging out. Podcast, watch the trial, watch the Netflix documentaries, watch the new movie, etc. I mean, when you get to watching the new movie, that's a lot. Yes, depending on the charges brought at trial, I believe that anyone who's heard about RM case at this point would have already developed an opinion or bias with as many podcasts, TV shows, movie, televised trial, etc. Yes, I know some of the people involved in this case, and I've watched all the documentaries about this case and don't feel I can be fair and unbiased. It's fair when you know people. I've watched all the documentaries and the Lifetime movie. All the things. Podcast. Murdaugh Murders Podcast, now True Sunlight. Oh, hello, Mandy Matney. Impact and influence the Murdaugh family murders and other cases. True crime shows, HBO murder documentary, Deadly Dynasty, Netflix, Murdaugh Murders, A Southern Scandal, Oxygen Murdaugh special. No, normally I'd say yes, but in this case, given the defendant, I already believe he's guilty. Yes, this case began 2 months before I moved here, and I have followed it ever since. I followed this case since I moved here, as the boat crash happened 2 months prior. I've been shocked that the behavior of this defendant was able to go on. I feel that he is guilty of any and all charges. No. So much media on this person. So much media on this person. So much. We have followed the story as my husband is a distant relative of Alec Murdaugh. We're related. We have watched all news updates, Netflix series, received various updates through mother-in-law. I would review all the evidence and fact and be objective. I obviously have read and have an opinion on Murdaugh's case, though. Like, I'll be fair, but like, I know that dude. I've read extensively and followed the case, including the original murder trial. I certainly have an opinion. Yes, although I am a rule follower, I mean, a lot of us, and believe in justice, and believe in justice system and the law, I feel that there are consequences for actions taken against another human being when taken with malicious intent. I've watched the documentaries regarding his case. I have watched the trial and read plentiful articles on the case. I have spoken to neighbors of his relatives that grew up in Hampton County. It's like, do you know Murdaugh? Yeah, I've talked to people who grew up with him too. Same. I've spoken at length with people regarding this case, evidence, and his personal testimony. Yes, if in regards to Alec Murdaugh, he has been found guilty recently, I stand by that verdict. Oh, he's guilty? Yeah, agreed. I have read, viewed, and heard numerous accounts of a Murdaugh upon moving to Beaufort County. While I'm not a gossip junkie, I mean, fair. Well, I'm not a gossip junkie. I believe he has committed despicable acts on his family, employees, and associates. He is malicious and unforgivable. He should rot in prison. I'm not a gossip junkie, but he should fucking rot. That's special. I can understand. I can understand the motion. Here's the thing. The motion to change venue is generally premature when you are dealing with, will we be able to find a jury? We saw this come up recently in the Corey Richins case, where her attorney was arguing, we're never going to be able to find a jury. And the court's like, well, we actually have to ask them. They've asked these jurors now, they're actually asking people, can you be fair? And they're like, yeah, nope. Not with this one. Not for this one. Cannot be fair. This hearing is coming up tomorrow. Will I be covering it live? No. I have some appointments that I cannot reschedule for tomorrow because this hearing was not set when I made those appointments a million D years ago, because that is how doctor's appointments work. It takes a million D years to get them. So I have things I cannot miss tomorrow. Will I break it down? Yes. Do I think they will just inquire as of more jurors? Yes. Yes, I do. Do I think the state will say we need to ask more jurors? Yes. Yes, I do. Do I love seeing people like point out all of the things? Yes. Yes, I do. Anna said nail appointments. I did nails yesterday, but no, not nails. We got doctor's appointments. Nails. So Nikki said, if not guilty, why guilty shaped? I mean, I don't think they're going to get a transfer of venue. I think they're going to enlarge the jury pool and start asking for more jurors. That's what I think is going to happen. But that will be heard tomorrow. Tomorrow, I think we will also see Poot ask Judge Newman to recuse himself from everything. Judge Newman recused himself from the motion for new trial, and that is it. Not from everything. Do I think we'll see them ask him to recuse himself from everything? Yes. I think he's going to say, thank you, counsel. That is denied. I don't think he's going to do that. The Supreme Court said he did not have to do that. They denied that part of Poot's motion. And that's what's going down tomorrow. It's going down. So at some point, we're going to learn if this trial is going forward in 2 weeks. If it does, we're covering it live right here. So if you don't have the Law Nerd app, you're going to need it, because we might have live trial coverage starting in like 2 weeks. And you're going to want the Law Nerd app. Here's my goal for the app during live trial coverage. My goal with the Law Nerd app during live trial coverage is to be able to update you when new witnesses take the stand, when there's a lunch break, when we're coming back from lunch, and to just keep you in the loop throughout every step of the trial. So that's what we're doing. Angie asked, can we rewatch the hearing? I will cover the hearing early next week. I just don't know which day. I will cover one. I will cover it at some point. It just won't be tomorrow. So that. Let's get to questions real quick. All right. Let's do that. I love the app. It's my EDB companion. That is the goal. That is always the goal. I am ready for live trial too. I'm ready. But we're going to see what happens tomorrow. Could they try to kick it? Judge Newman has been real hesitant to let them kick this case. But if they have problems seating a jury, it's going to be a problem. I think they will expand the area where they summon the jurors. That's what I think will happen based on what we've seen. But live trial coverage is my favorite. I think it's some of your all's favorite too. So then we get to spend day in and day out together for like 2 weeks. So let's see. JC in the comments said, I have no idea what the app is. Is it available in Apple apps? Yep. The Law Nerd app is available in the App Store for your Android or iOS device. It is free. It keeps you in the loop. And I've got you. All right, let's go to questions real quick. And then I will try to get back to Corey Richins in some way next week, either through a quick bit or through finishing that hearing. But we are bumping into Thanksgiving next week, so it's going to get a little busy. It's busy, which is why you need the app, because that'll tell you when I'm streaming, because I spontaneously do things. And I'm like, oh, we're going to do this. So that is why you need the app. It is available worldwide in your app store. All righty. Michelle said, your Law Nerd app is so cool. Thank you. I love the Law Nerd app. I love it. I love it. I love it. I love it. Anne said, you can mute the app. It does get busy. And then unmute it when we're in trial. I saw some of you say, is my internet freezing? It's not me today. It's not me. Katie, did I buy a new router? No. The ISP provided me a new router. Will I buy one in the future? Yes. Yes. So app needs the suggestion box function. That is not an app function, because when we open up suggestions, we get a ton of them. That is a member function. But I ask in the member spaces, like, what do you guys want to see me cover? So that's there. Gotta admit, I wouldn't have been surprised if EDB was name dropped in the potential jury comments. I try to stay out of all of it. I don't want to be mentioned in lawsuits. Will the app be available for PC? Not all of us use smartphones. Alan, I don't know if we will have a desktop version of the app. We've been looking up if we can have a easily accessible tablet version of the app, but we will see. So, all right, let us continue. We are going to get to your super chats. For everyone who gifted memberships, thank you. You guys are like, oh, desktop based. We will see what we can do. Alley Cat, what would happen if a person saw all these docs about him, but could still stay neutral? I'm a very pragmatic person. I base opinions on facts given to me. I think that person can be questioned and the defense would probably kick them. I don't think they would automatically get kicked if they're like, I'm open to hear, like, I haven't heard about this case. I've heard about the murder case, but not this one. But we'll see what happens. I think the court is going to be leery of anybody that's watched a ton of media, because it becomes an issue for appeal. Truly. Aurelia, this was regarding Courthouse Becky. She shouldn't have been talking to them at all. Listen, I should be cleaning my house while I listen to this live stream. Instead, I started playing this damn Suika game. It's so much fun. Suika's so good. 2 months, I think everything in this is kind of messy and petty. They are both grown adults and both are so wrong to do this high school stuff. That was from much earlier in the stream. Late to the party, watching from the start at 2 times speed. That was 2 hours ago. Oh, because we're 3 hours and 15 minutes in. I'm going to have to zoom through questions. Why file tainted jury venue when he admitted guilt? Because he still has a right to a fair trial. He still has a right to a fair trial on these allegations. So, Christine said, I'm totally body doubling you today. Thanks, EDB. You're welcome. I hope you got all your work done and were very productive. I've got to check emails later. I will be putting on somebody's stream to do that. Good morning from Van Isle, Canada. Got my cinnamon spice coffee and maple cinnamon frosted flakes. That sounds delicious. Much love from Vienna. You got me through many a night shift. I'm here. Chamomile tea before bed. It is delicious. Love it. Welcome to all our new members. Dr. B like educating with his Ask a Dentist segment. Dr. B will be probably getting asked some dental questions when he comes on next Friday. Square pizza tastes better than round pizza. Uh-oh, Claire. Uh-oh, chat. I don't know. Is it the nostalgia of it? Tomato allergy, puffy lips is horrific. Tomato allergies are no bueno. Cheeky kebab with cheesy chips. That sounds delicious. You guys are going to make me hungry. Oh my God. You just come after Chicago. Flatbread is not pizza. You're like, it's not pizza. It's a flatbread appetizer. That's not pizza. Fair enough. Cerebral 82, thank you for the gifted memberships. We've got more opinions in the chat. Amber was like, pineapple belongs on pizza. We're going to have to get back to doing some of our court of public opinion fights. It's been way too long since we've done court of public opinion, and I miss them. We've just been so darn busy, Stephen said, in the famous words of Alyssa Edwards, rigomoris. I see all of the motions for Audacity. Chat, there were so many of them. We got you. Michael, it's okay. Forgot about today. Been getting ready for baby girl's birthday. That's excited. Replay crew today. Well, you're here and we're not on replay yet because we streamed forever. 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 Are you going to cover the 7M case? Maybe not. I'll take a look and see what happens. Spectacular coincidence that Becky made up a Facebook post of some anonymous person emailed about the exact same thing. The Facebook post situation is weird. The email is weird. Like, there's weird stuff. Did you know Suika is named after a character from an anime named Dr. Stone who wears a watermelon on her head, and her name is literally Suika? I thought Suika meant watermelon. I thought it translated to watermelon, but I did not know that. Artists, even though it is my birthday, this gift is for you. All your hard work. Thank you so much. Happy birthday.
I hope it's a good birthday. Go, artist. It's your birthday. We're going to party like it's your birthday. I'm not drinking Bacardi, though. I can't.
I have things I must do tomorrow. I am not allowed to drink today. Or eat much. So if I seem delirious, that might be why. Hi from Germany with a glass of champs. Cheers. Love to be a law nerd. I love to have you all as law nerds, especially when we're cheersing with champs. I'm ready. The only almost no tomato pizza is Demetto's. Next time you're in Chicago, go to Grand Avenue, try it. Thank you for the pizza. BFF had caterpillar cakes for her wedding cakes. Amazing. They need an octopus cake. Octo, go fight it out with Aldi's. Go fight it out with Waldy's. Go on. Go fight it out. Go fight it out with Aldi's. This is a spoiler alert. America gets this Friday. Wait. Do we get caterpillar cakes on Friday? I want caterpillar cakes. Wait, are we getting somebody Google me. Would you like me to send you some official Cuthbert cake? It does not travel well. I'll just wait until I come. I'm going to come visit. That is a very kind offer. It does not travel well. I will figure it out. Can we get James Egan cast in the musical? It would be a miss if he wasn't. He is very musically talented. We have all found his music on Spotify, and it's great. Can you please post a list of your favorite things that are on sale or not this holiday season? I absolutely can, Anne. And I do have my Amazon links. They're down in the description that have some of the things that I love. I will put some more things into the Amazon shop so that we can. Round 2 of Food Fight Chicago style. We might need to do that. My birthday was the 12th, but glad I caught a live for a late present. Happy birthday, River. Thank you, Christina, for the gift of memberships. That's incredibly kind. Thank you, and welcome to all the new members. In New Jersey, the pizza wars are thin versus thick. I mean, that's fair. I feel like most of the wars that we fight. You could host a Caterpillar cake taste test. I could absolutely do that. It sounds amazing. Domino's thin crust pizza is square cut, but yummy. Fair. I have been through Amazon, need more ideas. Okay, fair enough. I need to add more things to Amazon. So with the judge yeeting himself, is he admitting guilt on Becky's part? Lisa Fox, this is a fantastic question. No. I think what the judge has said with recusing himself to hear the motion of new trial is, I think the admission I would take from that is there could be an appearance of impropriety or an appearance of bias because it is involving conversations with the court clerk, and it could seem that he is potentially a witness on this. Let another judge make that decision. I think it's the cleaner way to go. So I think it's the cleaner way to go, honestly. But I don't think it admits guilt. I think it admits that he knows a lot about it and he might potentially be a witness because some of these conversations with the court clerk, he was the other party there. So I think it's a good call. I think it's the appropriate call. Jennifer said after reading the whole state's response, 10 jurors signed statements, do not back up Egg Lady and her tenant. A hearing is not required, and it would be a terrible burden on the jurors. And it might not be granted. It might not. Did Judge Newman wait until the Supreme Court rules or recuse himself? I covered that at the beginning of the stream. He recused himself, and the court acknowledged it yesterday evening. Essie, thank you for the gift of memberships. I feel like it should be nap time. I agree. I agree. Talking about our Suica scores. Damn, I'm over here topping out at 2,600. It is hard for me to get to 3,000 on Suica. 11,000 is just savant level. Like the best in the game that ever was. I want to be the very best. Like it is master trainer level. It's incredible. I love it. David, welcome to almost the 1 year mark. Yay. Thank you everyone who gifted memberships, of all of them. Beth, did you hear about the Gwyneth Paltrow musical? We talked about it in Quick Bits. This probably came in before Quick Bits, but we did. Susan, thank you for the gift of memberships. I love this community so much. Y'all are the best. Wolfheart, I agree. This is the best community. And people ask me other things. I talked about this in members only yesterday. People ask me other things about YouTube. I'm like, can I tell you about my community? If plays in New York, we could make one show in EDB meetup and take over the theater. I'm totally down. We could do that. Can Becky be held legally responsible if fuckery is found? Becky is an elected official. I'm sure there are procedures if it is a problem. There is room for there to be conversations that are not ideal, that also are not a problem. So could this be a, hey, don't have these conversations with the jurors? Yes. But if Becky's having these conversations with the bailiff there, jurors approach the court staff and ask them things all the time. And they're like, hey, here's the bailiff. This is how we handle it. There is conversation that has to happen, especially early on in a trial. So I don't know how much we're going to have to wade through that. We'll see. What would the standard of proof be at an evidentiary hearing to prove whether there was jury tampering? The question is whether or not what happened influenced the jury, and the court decides that. By what level of evidence? I don't know if it's a preponderance standard. It's the standard to get to the fact that it impacted the jury is very difficult. But if a juror says this impacted me, the court makes that decision. So I don't even know if they put a standard on it. I would need to look. Off the top of my head, I don't know. The last time I covered that in depth was with regard to the juror that had issues in the Maxwell trial. And I went through the standard in New York. It is a high burden for the defense. Can Pook get in trouble for threatening subpoenas? I mean, could jurors, if they felt intimidated, complain to the state bar? Maybe. But it depends on what he said. Like, okay, if you don't want to talk to us, we'll have to subpoena you is different than you don't want to get subpoenaed and we're going to subpoena you and drag you into court and this is all going to be much more difficult. Or if we subpoena you and then you don't respond, you'll get arrested. Like, it depends on what was said. But no, generally not unless they complain to the state bar. And even then, the state bar is going to be like, I mean, that's what he will try to do. Whether he could get one is different. Poor Judge Newman has to be like, can we please bring the retirement? I don't know. I feel like Judge Newman is like, can we please stop the fuckery? I'm not going anywhere. I'm behind here. You played the screaming goat and my sleeping dog jumped up under her cozy blanket. Sorry for scaring your dog. Ultimate question. Did you get the red Starbucks Stanley? No, never even saw it. I got this one. Only because Chris sent it to me. I didn't even see it. I was in Vegas when they came out, running around at BravoCon. Didn't even see it. Kelly Garcia, thank you so much. I just learned about Judge Learned Hand on the Surviving the Survivor podcast. There you go. Oh, Judge Learned Hand. Sugar Mag said, Paltrow musical sounds stupid but brilliant. I mean, it sounds like it could be very fun. It sounds like it could be very fun. Okay, y'all. I know I didn't get to all of our member chats. I have got to roll. It has been 3.5 hours. We will try to do a quick bit of what's going on with Judge Newman to just help with everything. For those of you just coming in or catching the end of this, I talk about Judge Newman and what the Supreme Court ruled at the beginning of this stream. Judge Newman only stepped down from the motion for a new trial. With all of that, thank you, chat. I will be off of the interwebs tomorrow. I will see you back here probably over the weekend to do a quick catch up on what's going on with Murdaugh, and then I will update you in the app next week. I'm going to try to squeeze in an extra stream next week so that we can cover both what's going on in Murdaugh and what's going on in Richlands before the Thanksgiving holiday, and then there will be a members only Friday. Don't forget the 51% off preponderance of a sale over at Gerard Cosmetics. Thank you to our mods. Thank you, everybody, for hanging in for the long stream. It is time to go. May your Wi-Fi be strong, friends. Go download the Law Nerd app, and then you'll be in the loop for all of next week's scheduling nonsense. Bye.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.